Please, Your Lordship. I will tell us item number 4, my lord. Regarding item number 4, my lord, a report was called from the DGP, my lord, but has not been received, my lord. We have taken concern from the government, my lord.
2014 matter.
Yes, my lord. The inquiry report has been called from the office of DGP, my lord, but it has not been received yet, my lord.
Wait for a few minutes. Let us see.
My lord. Oh, yes.
Yes, ma'am.
Lordship, item number 1 and item number 16, adjourned for today, Lordship. We have some personal difficulties. So matter may be listed on Friday or any date, Lordship, except 8th of February.
On the prayer of the council for the list on 5th. 1 and 16. 5th. Yes.
Oh, Lordship.
That's the Lordship. I beg to mention item number 10, Lordship. Conducting counsel, Mr. N. Hassan is unwell, Lordship. Lordship may kindly take up this after 2 weeks.
Let the matter reach.
Lordship, he has been suffering from flu, so Lordship.
Let the matter reach.
May please, Your Lordship. Also, we intend to file an additional affidavit in this matter, my lord. Kindly give us 1 week's time, my lord.
What's your good name?
S. Nawaz, my lord.
For the prayer of Mr. S. and counsel for the petition. Wait, that just for a week.
Deeply obliged.
And all it. Yes, Mr. Sharma. On earlier occasion, Miss U. Sharma, government advocate, she appeared and supposed to apprise the court.
That report, my lord, far is not received. He will inform me that.
No, in fact, petitioner is also not here, but the complainant hasn't been informed either by the court or by the police regarding the closure of the.
My lordship.
This is Panbazar PS case number
Yes,
394 of 2017.
Yes, lordship.
Yes, Ms. Chaudhary, your matter is going on. Have you received any information?
No, Lordship.
No, my lord.
Get hold of Miss U. Chaudhary, U. Sharma.
Yes, yes, lordship.
We'll see. Wait for some time. Immediately, before we start any hearing. Get hold of her. What is the information?
Lordship.
Yeah. Identify for him. Was submitted in 17. No. Cases of 17. FR is a 2031st of October 2007. FR is the photo recorder. Directly Yes, Ms. Chaudhary, what about your RTI appellate matter?
From the RTI to, I have not heard anything as of now. Your lordship has called for the record the last week.
I'm going to go fun bazaar. With your husband.
We'll have it after some time.
Lord.
Call her. Yes, are you appearing? You are calling from whom?
I'm appearing on behalf of IPD for the lordship.
Who is Mr. H.K. Hazarika, government advocate? When did you communicate?
Lordship say he communicated, my lord. On 11/1/2024.
Amuguri is so far that you cannot get the information about the status of the case. Give us at 2 o'clock. Ask the DCP to provide the information at 2.
Yes.
Amuguri is not that far.
I'll call.
Yes, yes.
Hazarika, I'll
You
call.
have to tell us about the status. Before 3. Yes. What happened? Any information from the CJM Kamrup matter?
No, lordship, last time we had communicated to the OC for appraisal of the judicial order to that effect, any,
Have
if
you
any.
got into the notice of the Lanet CJM?
Lordship, that,
Whether the
that
OC
I believe
got
has
into
to go from the registry of
For
the,
that purpose, whether the OC has informed the office of the CJM or not. When did he
I had inquired about it. He has not received any instruction, lordship.
He may not have received any instructions, whether did he inform? Because earlier there was a communication placed by you,
Yes, lordship.
right?
Yes,
So
lordship.
you have also intimated the CJM for the information.
Yes, lordship.
Now, in that case, whether the OC has submitted that particular letter of yours before the office of the CJM or not.
He has submitted, lordship, but he has not received any
When
instruction.
did he submit it? Did he receive anything from the office of the CJM?
No, lordship.
Then how do you say?
Lordship, he
Without
had
any-
personally gone to the,
Without any seal and registration number, can you say that there is an information given to the CJM?
lordship.
It may be mayor and IOS, nothing else. Any order passed by the court definitely will be acted by the Lanet CJM.
Lordship, we have received one instruction from the Deputy Commissioner of Police. Lordship, may peruse.
So was that communication by which it was information was sought from the office of the Lanet Chizem Kamrup Metro? Had MS B. Chaudhary, Lanet Council appearing for the petitioner. And MS U. Sharma, Lanet Government Advocate Assam. For the respondent numbers. One, two, and five. 1, 2, 4, 5. Notice in this case was issued on 15/09/2023. On 21/11/2023. The respondent number 5 officer in charge of Panbazar Police Station placed before the court that by communication dated 07/11/2023, he sought for a report from the office of the Chief Judicial Magistrate Kamrup Metro regarding the status of the FR number 443/2017 dated 31/10/2017. It was submitted pertaining to Panbazar Police Station case number 394 of 2017. Registered on the basis of an FIR lodged by the petitioner on 26/07/2017. Copy of the communication dated 07/11/2023 of the officer in charge, OC Panbazar Police Station, also reflects that the office of the CJM Kamrup Metro received the said letter on 07/11/2023 itself. By an order at the 21/12/2023. Accordingly, on 21/11/2023, the court directed the government advocate Assam to apprise the court about the status of the said final report number 443 of 2017 noted above, fixing the matter on 21/12/2023. On 21/12/2023, next page, the court fixed the matter today, enabling the CJM Kamrup Metro to furnish the relevant records. Today, Ms. U. Sharma, Lal Government Advocate Assam, apprised the court by placing the communication of the Deputy Commissioner of Police, Central Police District, Kamrup Metro, dated 10/11/2023. Placing that such report from the CGM Kamrup Metro has not yet been received. Placed on 16/02/2024. And on the said date, Chief Judicial Kamrup Metro shall apprise the court about the status of Panbazar Police Station, case number 394/2017. Registered under sections 406/468/420 IPC on the basis of an FIR lodged by the petitioner on 24/07/2017 and also about the status of the final report submitted by number 443/31/10/2017 by the investigating officer of said Panbazar PS case number such and such after investigating the matter. Registered Judicial shall communicate this order to the Chief Judicial Magistrate Kamrup Metro Guwahati Court which for her necessary appraisal and for her necessary appraisal. The last of the 21/11 Deputy Commissioner of Police 21/12/2020.
Obliged, deeply obliged.
May please your lordship. My lord, here in this case, my lord, the impugn order as
Mr.
case.
Caesar, No, this is not in particular specific. Just. Please take your. Bro.
Someone like Silami.
Yes, Mr. Gopal. Here for item number 13 in that series.
Please.
See, our officers hasn't received a letter on email, in fact, but it was not as per the format. So it was communicated to them, the immediately after 10:15. Now they have sent a format, which is, they have sent a format as per the format, but not as per the specifications given by the High Court. So when it is not as been the specification, we normally cannot allow for such online mode of argument. This matter was fixed today as agreed by both the parties. And first of all, they also did not fill the format accordingly. What do you suggest?
Keep it at a convenient date, no problem. Or if you,
Do one thing, ask her to talk to the other side.
or if you feel it proper, I can address you for 20 minutes.
No, we can fill it because see, it will be no point. We do not know
Correct.
our next bands. Whether both myself and my brother will sit together from Monday onwards. Even if we fix a date, it will remain as a partner. So we think to take a letter talk to the other side and fix a date and then intimate us, because that date has to be agreed by both the parties.
Right.
Then if on the same date the other side doesn't appear, we'll definitely proceed. Otherwise, we like to hear you.
Right.
But we also do not know whether we'll be sitting together from Monday onwards.
No,
So our bands.
we'll find out the convenient day
Exactly.
and then we'll mention it.
That will, I think, so we can hear you from the morning,
That's right.
because you will be also an outstation lawyer.
That's right.
So we'll give you that preference.
So we'll just check up the date and
Ah.
report.
You fix it such a manner that in a Tuesday, if it is possible, so
Right.
you can carry forward for a Thursday. Or on a Thursday, so that can, after argument, go back.
I think
come
it
back.
will take only 30 minutes, this case, not more than
But
that.
since you are from Nagaland and the other council also from Nagaland, we'll give you that benefit, you just make a mention.
So we will do accordingly. We'll report.
So, Mr. Balgopal,
I'll-
take a convenient day and let us know.
Right.
Yes.
We'll accordingly fix.
No problem.
Mm.
Whether the impugned order at case 60. And I said,
Mr. Siddha,
my lord,
just few minutes,
Well-
come back to you.
my lord, in the meantime, may I go through the records, my lord? Lord for record.
Go through both of you
Yes, ma'am.
together. We'll see.
I find something. NRC কথা লিখিছে নেকি চোৱা আপুনি? NRC page 34 NRC page 35 বুলিহে। Page 35 पे लिखा नहीं, page लिखा है, लिखा है page 35 हाँ page 35 page without signature. ডক্টৰক নোটিছত নিচে বাপেকৰ নাম লিখিছে। নোটিছ ৰেকৰ্ড লিখিছো আমি কিন্তু কমপ্লিট লিখা নাই। স্টেটমেন্ট লিখছে কিন্তু সিগনেচার তোমার দিয়ে হবো মুসলিম মন্ডল তোমার সাইটেশন তোমার আরো কি কথা আছে বাপেগার নাম নিজে লিখেছি এতে এতে তোমার হায়দার আলী টু হায়দার আলী মুসলিম মন্ডল টু আহিব ইদ্রিস আলী টু আহিব হায়দার আলী কিতাপটো দুটাহে কপি আছে হায়দার আলী তোমার ইদ্রিস আলী তারপর তোমার सुना सुना है सुना खाना है सुना पहले किस विषय पे रहता है आपको लगता है नहीं सब दे सर सर ना बोले लीटर T20 কথা বলে বেশি কথা বলে মমতা না Itu. Hmm? Itu bukan pada itu. Tapi kita bawa sih. Itu aja. Hmm? Report no. Agriculture division में तो जादमें तो ये डबल पूरे बड़ी थे मिशन करना के रिपोर्ट करो चला तो न करे he has been to Lexi is a Abdul Matal Nigeria value mana juga di ಆಗಿವ লাগে হ্যাঁ বাকি ভালো আছে হ্যালো জাজমেন্ট নেই
Yes, Mr. Sigdev. We have seen that. Please, you start from your written statement. Yes. Hmm. 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 No, impugned husband definitely rejected your case. That we know, did not consider discrepancy in the age. Now, Mr. Sikdar, please come to page number 20. Just queries, you just answer to these queries. This is her written statement, right? Read para 2 very slowly. So her marriage was about 35 years ago before filing this written statement. So since then, after her marriage, last 35 years, she is residing at Khoponikusi, right? With her family in village. No, living in this same address, in this side address. Now, prior to her marriage. So, prior to her marriage, her written statement clearly says that 35 years back I got married with Ainul Khan. And since then, I'm in residing at this particular village at Khoponikuchi. Prior to that, she was residing at Holongabari, right? That is 35 years prior to her marriage. Then she was born at village Mespara. in the said village Mespara, Moja Hauli, police station Borpeta, district Borpeta. Okay, fine. In this particular written statement, she named her father as Muslim Uddin, mother as Sukurjan Nesa, and grandfather name as Dabir Uddin. Her husband name is Ainul Khan. In this written statement, right, right. So this is what she said. But in her written statement, she did not state the name of her any siblings or any other children born to Muslim Uddin. She is totally silent in that regard, right? Now, two voter lists of 1966 and 1977 relating to village Mespara has been annexed, and where in the name of one Muslim Uddin, son of Dabir Uddin, and Surajbhan Nesa, wife of Muslim Uddin, has been reflected both in the 1966 as well as in 1970 relating to village Mespara of district Borpeta. Right. Thereafter, a voter list of 1985, which she has exhibited with her husband relating to the village Khoponikosi, where she resides since her marriage. And in the year 1985, she was 30 years age. So she was eligible as a voter. If she was 30 years is 1985, she was born sometimes in 1955. So she was eligible to vote by year 1976. But for the first time, she has also admitted that I have cast vote after my marriage with Ainul Haq at Khoponikosi. That is her statement. Her name did not figure in any voter list at village Holongpara, right? Though she was eligible. No. 30 years means 30 minus. So it will be 55. 55 plus 21, 76. 18 has become only from 1989. So her name should have been somewhere in the voter list prior to 1985. It is not there. Anyway, so she had also given her EPIC card. Fine. Now page 32. Gaon Buddha certificate. First of all, it has the national emblem, and he has given the certificate clarifying that she belongs to his Lat Holongbari, and that she is the daughter of, right, she is the daughter of one Masir Khan, Khoponikosi, married with Nasir Khan's son, Ainul Khan, and he saw that her father's name figured in the voter list of 1966 at village Mespara, right? Now, right, he deposed. Now, see his deposition. Anyway, let us go to the page number 40. This is the cross of the proceeding. Read very slowly again. Hmm. No. For the first time she has said it, right? Fine. Now page 40 again. What is the age of the proceedee? 55 years. In her written statement also, she said 55 years. So, apparently, she got married sometimes in the year 1980-81, as per her own statement, because proceedee is aware when she got married, at least, if not the year concerned, how many years at least she'll be aware. Now, please come to the cross of the Gaonbura. Kindly read Moi 2011 চনত. It is Ulongbari, but not Holongbari, which is very surprising. Achha. Hmm. Hmm. So you have read very carefully and you have read it for second time. Listen, listen. Fine, very good. Please come to page number 47 again. Or before that, you can come to page number. He was crossed on 27th of April 2016, right? And he submitted his evidence in affidavit on 30th of March 2016, right? Now come to page 47. Read the first line, DW2. Then, no. Read at the top, DW2. Now, if he is 28 years in 2016, now what will be his birth year? If he is 28 years in 2016, what will be his birth year? So, just tell us one thing. You have read this evidence twice. I am reading it for the third time. মই প্ৰচিডি লালবানু বেগমক চিনি পাওঁ। মই গাঁওবুঢ়া হোৱাৰ আগৰ পৰা চিনি পাওঁ। কিন্তু তেওঁৰ কেতিয়া বিয়া হয় মই নাজানো। প্ৰচিডি ঘৰ হলংবাৰী গাঁৱত। মেছপাৰা গাঁওখন প্ৰচিডি স্বামীৰ বসবাস কৰা বুলি মই শুনিছো, which you have said that he has wrongly stated. Now, how old is this গাঁওবুঢ়া? How old is this গাঁওবুঢ়া? 28 years. As per the procedure, when did she got married? Got married 35 years back, prior to the birth of the Gaonbura. And since then, she's residing in Holongbari, where from the Gaonbura will know that the procedure, she is aware about the procedure. So that is his what knowledge? his personal knowledge. Just a- When will be, which is the particular date that's it for Mr. Balgopal? We fix it on 8. Inform. Just the forward. Mr. Sigda, please take your seat.
Item number 30 to 50.
Or Mr. Ken Balgopal. Learned Advocate General Nagaland. Assisted by MS. M. Kechi, right? Oh, sorry, I'm extremely sorry. T. Crow. Senior Government Advocate Nagaland. For the petition. This matter was fixed today by order dated July, by order dated 14/12/2023. This matter was fixed today as agreed by the land council for the party. However, the respondent side remained without any representation. Learned counsels representing the respondent are from Nagaland, as reflected from the Wakalatnama filed on behalf of David Discus. You talked with whom?
Lordship, Zimomi, Chekeli Zimomi.
Learned Government Ms. Crow. After telephonic conversation with Mr. Jimoni, counsel for the respondent, committee. That both the parties agreed for hearing the matter on 8th of February. 2020. Matter be accordingly fixed for hearing on 08/02/2020.
Obligement. I shall inform accordingly.
Please do it. Ms. Crow shall inform Mr. Zimoni, counsel for the correspondence. Yes.
My lord.
Okay.
2016, my lord, the Gabura was aged about 28 years as per his deposition. My lord, in that case, my lord, he was born around in the year 1988-87, like that. But he is Gabura of that Holongbari village, and the proceedings parent village is also Holongbari. So the visiting terms is there.
Definitely there.
There may.
That's how she
therefore,
knows.
He may have the knowledge.
That's right.
So it cannot be conclusively said that he has. no
Please
knowledge
come to the another sentence.
My lord.
Page number 48. Second line.
My lord. Moon Latot Lalvano number 1 Kunu Tirta 9.
Very good. The proceedee has subsequently gave a voter list of 1997.
97. Yes,
Of course, that's not a certified copy, but it was placed before the tribunal.
tribunal, and that has been discussed also.
Now, please come to page number 59. Look at the serial number 650.
65. Lal Bhanu, yes, sir.
Look at the village at the top.
My lord.
What is that village?
Holongbari. My lord, Lal Bhanu, he is wife of Hakim. Hakim is the brother.
No, we are
Yeah.
not saying that. Please come to page number 59, 59 at least.
59. My lord.
15, not 59.
Hakimuddin is the brother who 649. And Lal
Page
Bhanu-
number 48.
My lord.
Who is the proceedee?
My lord, proceedee is the Lal Bhanu, my lord.
Lalvan.
But that Lal Bhanu is the brother's wife.
The statement made by the Gaura is more latot lalvanu namor aru oin kuno manu nai. Right? And this particular voter list reflects a name of Lalvanu in the same village in the voter list of 1997. That's what we're saying. We're asking you. The village headman saying that in his lot there is no other person by name of Lalvan. The voter list of 1997 adduced by the proceedee shows
My lord, the Gaura,
existence of.
Gaura made
Gaura.
some other mistake also. My lord, I
That
saying.
is why you have, this is brought it to your notice,
My lord,
that's all. Yes,
My lord, I maybe completed my submission.
okay, you must finish it.
My lord, I want to go through the, my lord, the Impun order.
Hmm.
Not all parts, but some relevant parts.
Sure.
My lord, in para, under para 2, claims of the proceeding in the written statement.
Hmm.
Then my lord,
Just give us the paragraphs.
my lord, paragraph 2, page 61.
Written statement.
Then my lord, in the written lowest part, in the written statement, the proceeding is also internally stated that her name has been appeared in the voter list of 1985 under 55 number Hazu LSC at village Kopnikosi under Hazu police station in the district of Kamrup, that she is the daughter of late Muslimuddin father and Tukurjan Nesa mother of village Mespara, and their name appeared in the voter list of 1966 and 1970 under 50 number Borpeta LSC of village Mespara in the district of Borpeta. That she got married with late Ainal Khan, son of Nasir Khan of village Sonso, about 35 years ago, that before the marriage, the prostitute used to live with her family at village Alangbari under Moza Bizni in the district of Barbata, Baksha, and the prostitute was born in the said village. That the parents of the prostitute had shifted to village Alangbari in the district of Barbata from village Mespara in the district of Barbata in the year 1970-75. The prostitute has got voter ID and the voter ID. Then, my lord, discussion, my lord, I am,
Para 4.
my lord, I am, para 4, my lord. In support of the claim as narrated by the written statement, the prosecutor has examined 3 witnesses. Herself, DWS Dirolon, Ramshari, Gaura, and a village Holangbari. Then one Jamal Khan. My lord, I am, my lord, in evidence part, my lord, page 63, paragraph 5. According to the prosecutor, Lal Banu, she is a citizen of India by birth and permanent resident of village Kopnikosi in the district of Kamrup. And prior to her village, she used to live in Sonso, born in Sonso. She got married to Ainul Khan, son of late Nasir Khan. But the proceeding used to cast her vote since 1985 under Sonso. Then, my lord, she is the daughter of late Muslimuddin and late Shukurjan and granddaughter of Dobiruddin, that her father died about 20 years earlier and husband died about 10 years. That the proceeding name were recorded in the voter list of 19. Parents of the proceedings name recorded in voter list of 1966 and 1970. That the parents of proceeding had shifted from village Mespara to village Holangbari when she was about 10 years old, and the correct name of the proceeding is Lal Banu. But in some documents, her name was recorded as Lal Banu Begum in place of Lal Banu, and her father's actual name is Muslimuddin. But in some documents, his name is appeared as Muslim in place of Muslimuddin, and her husband's actual name is Ainal Khan. But in some documents, his name is appeared as Ainal Khan. Then during cross-examination, well, DW1 stated that at present he is residing in village Kopnikusi, that after her marriage, she used to cast her vote at village Kopnikusi, that she has two brothers, Hakimuddin and Shukumuddin, and they cast their vote, and as such, she will produce their voter list before this tribunal on the next date, that she is daughter of late Muslimuddin and Shukurjan. Utpal Ramshari, the government Gabura, of village Holangbari, stated that she was appointed as Gabura about 5 years earlier, and she knew the proceeding for about 19-20 years. That the proceeding used to cast her vote at village Nikusi. During cross-examination, DW2 Utpal Ramshari has narrated that he was appointed Gabura in the year 2011, that he knows the proceeding before he was appointed as Gabura, but he does not know in which year she got married. Exhibit A is issued to him. Jamal Khan, DW3, son of late Bhelu Khan of village Kupnikusi in the district of Congress, narrated that he knows the proceeding since about 40 years ago, that the proceeding used to cast her vote since 1989. And he is the daughter of Muslimuddin and Shukurjan. Further, DW3 narrated that the proceeding is his relative. During the cross-examination, DW3 stated that the proceeding is her aunt, and he knows her after marriage. But on the request of the proceeding, he adduced his evidence before this tribunal that the father of the proceeding died about 12 years earlier, that the father of the proceeding was residing at village Holangbari. Now, my lord, appreciation of evidence on record. At the very outset, it is noticed that Exhibit H, which is exhibited by the proceeding as NRC 51, on a close scrutiny, the same appears to be photocopy of NRC entry certificate. That being the position, the Exhibit H cannot be accepted as proper document. But I have gone through the record and seen that that was signed by the member. So, my lord, even if it is a photocopy, how that cannot be accepted, my lord? The member has signed it. May not consider, my lord, as an evidence, but it can be my lord, considered for corroboration, my lord. NRC, my lord, 51 is the basis of identification in the NRC process, my lord. So it cannot be ruled out in the manner that the tribunal has done. Now, my lord, the second part of this appreciation, very important, my lord. During cross-examination, the proceedee DW1 has narrated that her father, late Muslimuddin, son of Dobiruddin, cast his vote in the year 1966, Exhibit D, and the year 1970, Exhibit E, under 50 number Borbeta LSE at village Mespara. In the Exhibit D, age of her father was mentioned 40 years. Yes, my lord. 40 years. How the year of birth, my lord, calculated? 1966 minus 40, my lord, 1924. It's a wrong calculation, my lord. It's a simple arithmetic of class 3, my lord. And that has been done, my lord, mistake, my lord. It will be, my lord, 1926. But it is calculated as 1924. Then, my lord, and in the exhibit, his age is 44 years. Yes. Then how 44 years, my lord, the date year of birth calculated? 1970 minus 44, 1934. This is also a mistake, my lord. 1970 minus 44, it will be 1926, not 34. Again, similar mistake, my lord. The tribunal member who is deciding the citizenship do not know how to conduct a, my lord, a arithmetic calculation, my lord, of class 3 standard, my lord. And exhibit G, his age is 91 years. My lord, this 91 years, that is a mistake, my lord. Date of birth. Thus, there is a serious contradiction regarding the date of birth of her father. DW1 has also stated that her grandfather's name is Dobiruddin. But in the Bhuta list of 1997, her grandfather's name is shown as Dobir. My lord, against the relation column, in the relation column, always name is written in short, my lord. The DW1, the proceeding states that in her written statement as well as in the evidence in chief, she used to cast her vote 1985 at village Kupligusi, but curiously enough, she has submitted only the voter list of 1985 under 55 number LSC at village Kupligusi in the district of Kamrup. The reason as to why he has not submitted such voter list of the others cannot be clearly understood. Another important point, as stated by DW1 at para 8 of her evidence in chief, that her parents shifted from village Mespara to village Solangbari in the year 1970-75, about 40-45 years ago, why her parents had shifted to village Solangbari is not mentioned by the said proceeding. And in this regard, the proceeding has not submitted any documents, but has only submitted the voter list of 1997 of village Solangbari, although she proceeding has stated that her parents had shifted to village Solangbari in the year 1970-75. Why she has not submitted the voter list of village Solangbari for other years cannot be reasonably be understood. But it is not found from the evidence of DW2, DW3 that father of the proceeding had shifted to village Solangbari, and it is only plea made by DW in her evidence. In the light of the discussion, the proceeding, Lal Bhanu Begum is found to be failed to discharge her onus of proof as provided under Section 9 of the Foreigners Act. My lord, absolutely based on a wrong appreciation of the evidence, my lord. My lord, in the voter list, my lord, in the writ petition, I have annexed one voter list, my lord. Only for clarification, lord, you will find in page 68, annexer 16. Here, the 85 voter list of father in village Solangbari. Vernacular at page, in the next page 69, my lord. Muslimuddin is the father, son of Dobiruddin, is 59. Shukurjan mother 60. Then Hakimuddin is the brother, is 30, my lord. Here, the age mentioned is similar with the voter list of 1970 and 66, my lord. Only, my lord, discrepancy in the age discrepancy in 1997 voter list, which was produced before the tribunal during further cross-examination without explanation being furnished, my lord. That is there, my lord. But in our writ petition, my lord, we have given an explanation. How, my lord, there was a survey report in the village. The petitioner in para 12, lordship may kindly have a look at, my lord. There was survey in the village, and as per the survey conducted by enumerator, it is to be 71. The age in 1997 is to be 71. But during printing, it was wrongly typed as 91 years instead of 71. And RTI application was submitted by the son of the petitioner, and no reply has been given. So, my lord, the mistake in the voter list of 1997 is a mistake committed by the authority, not by the voters. And 66, 70 voter list are telling. Then, my lord, 85 voter list also matching. So, only because of one mistake in the one voter list, the whole evidence shall not go, my lord. And in this connection, my lord, we want to realize some judgment, my lord. My lord, the judgment passed by the division bench led by Justice Unima Hazarikan LH Jamir, my lord. In that case, my lord, he reported as 2015 2 ZLT 617. In that case, my lord, this honorable court has
617.
my lord 617 2015 2 ZLT 617. Para 9, my lord.
Right.
May I furnish copy, my lord?
No, it's okay. We have.
My lord, yes, my lord. In para 9, my lord, in view of the facts and circumstances narrated herein above, the question arises as to the scope of interference of the tribunal order in the writ proceeding under Article 226 of the Constitution, confers on the right confers on the High Court power to issue appropriate writ or writ to any person authority within its territorial jurisdiction. It has been held by this court that the tribunal constituted under the Foreigners Act 1946, read with Foreigners Tribunal 1964, is equipped to discharge the quasi-judicial function. The High Court therefore has the power under Article 226 Constitution to issue writ of certiorari quashing the decision of the tribunal in an appropriate case. The scope of interference with the tribunal order in exercise of jurisdiction under Article 226, however, is limited inasmuch as the writ of certiorari can be issued for correcting errors, jurisdiction, or failure to exercise the jurisdiction of or if such court or tribunal acts illegally in exercise of jurisdiction or failure to exercise jurisdiction, or if such court or tribunal acts illegally in exercise of its undoubted jurisdiction, or when it decides without giving an opportunity to the parties to be heard or violate the principles of natural justice. The power of writ court under certiorari jurisdiction being the supervisory, not appellate jurisdiction, the court cannot review the findings of the court of facts reached by the inferior court or tribunal. However, writ of certiorari can be issued if prima facie found in the tribunal's order an error apparent on the face of the record, as noticed above has occurred in the instant case, and the appellant had examined herself as a witness and had also exhibited as many as 9 exhibits, veracity of which are not put to challenge. On behalf of the prosecution, no evidence was laid per contra. It is true that under the scheme of Foreigners Act, the initial burden of proof lies on the appellant, and he had successfully discharged the burden. Having done so, the onus to prove the prosecution case shifts on the prosecution, which was not discharged by the prosecution. The contents of the documents proved at trial and not contradicted by the prosecution has to be deciphered by the tribunal judicially. The doubt, if any, which might arise in the mind of the tribunal must be answered not like a common man, but like a prudent person who is trained in law. The instant case on the face of the evidence on record brought forward by the alleged foreign national was unduly interpreted against him merely on the basis of some discrepancies as regards the age of persons concerned recorded in such documents. It is to be noted that those persons concerned, including the appellant, were not the writer of those documents. The ages so recorded in those documents do not point out discrepancies, but they are not so major as to totally disbelieve the disregard and belie the evidence of the appellant petitioner so as to disrobe the precious most right of the citizen of a country, my lord. So, my lord, very lucid and very, my lord, reasonably explained, my lord, the situation, my lord. Here, wrong entry in the voter list, the proceedings should not suffer. And my lord, this is I'm relying on this because there is some wrong entry in 1997 voter list, and it was placed before the tribunal during further prosecution. So, my lord, 85 voter list also I've given in the writ petition only because for clarification, her linkage, her legacy is proved by the voter list of 1967-70. So, my lord, mere here and there some mistake, the prime evidence shall not go, my lord. The Gaura and the Jamal Khan, who was present in the marriage, my lord, they have said nothing adverse to the claim. And, my lord, kindly have a record, my lord. In the record, my lord, it is their own, the proceeding, my lord, the prosecution, my lord, the notice indicates that she is the daughter of late Muslimuddin. So, my lord, only burden, my lord, then rise whether Muslimuddin is the citizen or not. And that has been proved, my lord, by the voter list of 66 and 70, my lord. So, my lord, only because of here and there some mistakes, the whole evidence cannot be discarded, my lord. In that case, my lord, I am relying on the voter judgment of the Hyder Ali case, my lord. Hyder Ali case, my lord. My lord, it is reported as 2021 3 GLT 85. Here, my lord, yes, my lord, the WS is not proper. The advocates so prepared, my lord, they are also not, my lord, well equipped, my lord, that is there, my lord. But evidence, she mentioned her brothers. And WS is not the, my lord, is not mandatory. WS is not mandatory. My lord, here, my lord, only, my lord, the evidence part is to be considered. That is also in the Muslim Mandal, my lord, in the Sarvandarsundal case, my lord. Evidence part, only evidence part. And in paragraph 29 of Hyder Ali case, my lord, I am reading some relevant paragraph, my lord. Paragraph 29, from the above, what is important to note in the Foreigners Tribunal constituted under the Foreigners Tribunal's Order 1964 merely provides a reasonable opportunity for making representation and producing evidence in support of his case before the tribunal. And as such, normally the rules of pleadings, including that of written statement as provided under CPC, are not applicable. It is mandatory, not mandatory, but the, my lord, details WS is to be given, my lord. In paragraph, my lord, 42, my lord. There are other important paragraph, but
You are relying on 29 and 42.
My lord, 29, then 41 also. Referring the Sirajul Haq case, Sarvandarsundal case, the requirement of the particulars in the WS had been discussed in paragraph 42, my lord. Paragraph 42. On proper analysis of the aforesaid observation of the Honorable Court, the following aspect emerge. In order to establish one's citizenship, normally he may be required to give evidence. His date of birth, place of birth, name of his parents, their place of birth and citizenship. However, the Supreme Court nowhere states that aforesaid facts must be proved only by documents. The expression used is normally he may be required to give evidence. Thus, it is not mandatory to prove all these to show that he is a citizen of he is an Indian citizen. These are, however, relevant facts if one proves can establish beyond doubt that he is a citizen of this country, yet he may be able to prove his citizenship by other evidence as usual. Paragraph, subparagraph 3, my lord. Here, my lord said, one may prove one's citizenship without referring accurately to all the factors mentioned under paragraph 26 of Sovereign Sunwal 2 Supra. For example, if the date of birth or the place of birth is not conclusively proved, but if it is conclusively proved that the father of the proceed is an Indian citizen, the claim of the proceed cannot be rejected as a foreigner, as it would fly in the face of logic and common sense. Very important, my lord. My lord, father is a citizen, and that appears in the voter list of 1966, 70, and 85. Then paragraph, my lord, paragraph 43. Paragraph 43, my lord, because there is some shifting, my lord, and there is some discrepancy. Referring this Sirajul Haq case, my lord, in this case, my lord, there has been observation in paragraph 43. It may also be noted that the standard of proof in discharge of the onus by proceeding under Section 9 of the Foreigners Act is preponderance of probability, as has been also reiterated in the full bench decision of this court in the state of Assam versus Muslim Mandal 2013 1 GLT 809, that the standard of proof being preponderance of probability, there could be minor inconsistencies here and there in the evidence of the proceeding, which would not warrant rejection of the claim. This is what Honorable Supreme Court held in Sirajul Haq case versus State of Assam 2019 5 SCC 534. My lord, we are also relying on the Sirajul Haq case. My lord, the relevant paragraph of Sirajul Haq case has been quoted, my lord. May I read out, my lord? We have heard the learned counsel for both sides extensively, and we have gone through the documents produced by the appellant ourselves. On a perusal of same, we find that a number of documents have been relied upon by the appellant, starting with voter list of his grandfather Kematullah in village Choto Arjani. There is no doubt that the grandfather's name Amtullah appears as Amtullah throughout the document. Equally, there is no doubt about the father's name, which appears as Hakim Ali throughout. The only discrepancy found is that in some of the documents, Kefatullah later becomes Kematullah. However, what is important to know is that his father's name is Amtullah, continues as Amtullah, and the other family members associated continued as such. Also, produced the NRC of registration details of the year 1971 of the grandfather, who is noted to be Kefatullah in this document. Other voters list are then produced there. The voter letter F becomes letter M with other family names remaining in the same. In fact, the appellant has himself produced documents of 1991 from the Income Tax Department giving his permanent account number. Apart from these documents, certain other related documents have also been produced, including photo identity cards issued by the Election Commission of India and identity cards issued to his brother, including voter list in which the appellant's name appears. Having gone through these documents, we are of the view that it is not possible to state Kematullah is not the same, despite being named Kefatullah in some documents. This being so, the grandfather identity, father's identity has been established successfully by the appellant. Further, the mere fact that father may later have gone to another village is no reason to doubt these documents. This is also important, my lord. The shifting, my lord, has been explained in the WS as well as evidence. My lord, tribunal has recorded reason that no documents has been given of shifting, no reason why shifted. My lord, this should not be taken that way, my lord. And my lord, my lord, I am also relying on the judgment of this honorable court in the case of Idris Ali. This is, my lord, not a reported case, but it is WBC number 4116/2019. May I furnish my lord copy? It's not
Just a minute, just. Idris Ali,
Idris Ali versus Union of India, WBC number 4116/2019.
411.
4116/2019. Order is of 27 to 2020.
Dispose of on
27 February 2020. My lord, in this case, my lord, very short observation has been made in the judgment at page 5. Very short but very effective, my lord. Here, my lord, stated, quoting some other case, my lord, Union of India versus R. Gandhi reported 2010-11 SCC. The Supreme Court has some judgment and referring that this observation has been made by this court. Reverting to the case in hand, the strict rules of evidence are not applicable in a tribunal. Nothing is required to be proved beyond all reasonable doubt. My lord, we are relying these two lines, my lord. Well, here and there may be some mistakes, my lord. My lord, these are illiterate people, my lord. And big advocates who guide, they are also particularly, my lord, the advocates conducting the FT case, they are also not well versed. I am not blaming that, but that is the situation, my lord. My lord, there may be here and there mistake. WC is not properly written. Evidence is also not properly written. But the prime facts, the parents are voted in 1966, 70, 87, 85 also in Bhutan. In 97, there is a mistake. In 97 Bhutan. For that, my lord, the whole thing may not go. And my lord, the inquiry proceeding. My lord, the notice indicated her father's name, Muslimuddin. My lord, so you know that I am the daughter of Muslimuddin. So I am to show whether Muslimuddin is a citizen or not. That has been proved, my lord. There is nothing adverse material. Here and there may be some mistake, my lord. That has been clarified by the Supreme Court as well as the this old court in Hyderabad case. So for these, my lord, the evidence, whole evidence may not go and cannot be declared foreigners, my lord. My lord, in this case, my lord, I have filed some additional affidavit because, my lord, there is some order that they are shifting. How to prove shifting? This honorable court has said that you produce the voter list of after shifting of Mespara, before shifting to Holongbari. That I have produced, my lord. I have produced, my lord, there is an affidavit of 2017. My lord, I have filed affidavit as many as 3 affidavit, my lord. In December 2017 affidavit, I have produced the certified copy of the voter list of 1985 showing the name of parents and
page
one brother.
77.
My lord.
Which year?
85 voter list. That was submitted December 2017. That is also, that voter list also annexed in the writ petition, my lord. But I am to show, my lord, the subsequent affidavit, my lord, that I have produced, submitted on September 2019.
Then second affidavit.
So September
Second affidavit,
2019.
September 2000. What you want
19.
to show from
My lord,
the-
in this case, my lord, I have annexed one certificate of Gavura of Mespara. Gavura Mespara Abdul Mujib. He has issued a certificate at page 82, my lord. Annexer 19.
On which date he has issued that?
My lord, that is 93. That was issued in 1993.
To whom?
উপরোক্ত তথ্যসমূহৰ পৰা জানিব পৰা যায় যে মোহাম্মদ মুছলিমউদ্দিন মেছপাৰা গাঁৱৰ মৌজা হাউলি থানা বৰপেটা নগৰ ইউৰ নাম 66 চনৰ ভোটাৰ তালিকাত অন্তৰ্ভুক্ত উক্ত মানুহজন 70 চনত হলংবাৰী পোষ্ট অফিচ লৈ উঠি যোৱা সত্য my lord my relevant documents is of shifting annexer at page 84 the voter list of 1989 here my lord after shifting the family members are not voter in Mespara my lord. Then my lord I have also submitted another affidavit, my lord, that was the third affidavit in November 2023. Here, my lord, the complete voter list of 1965-70 of village Holangbari, showing that the family members were not voters in 1965 and 70, my lord. Then, my lord, 1971 voter list also Holangbari. They are before shifting, they were not voters in Holangbari. Then, my lord, the father of the proceeding during the period of disturbance in the BTAD area, they are hailing from BTAD area. They purchased some land in village Ramdia in Hazu, my lord, under Hazu police station in the district of Kamrup. And thereafter, they have sold out the land. Most portion of this land is sold out to one Abdul Kader that has been annexed in my lord, annexer 26. That documents father sold out the land, my lord. Then, my lord, a little portion remained, and in that part, the name of the proceedee and her brothers are mutated. That documents we have annexed, my lord, annexer 27, page 145, my lord. But there is a mistake in the grandfather's name. Instead of Dobiruddin, it is written as Robiruddin. We have to explain it, my lord. But the brother's name Hakimuddin, then Sukimuddin, and her name at serial number 25. That is the mutation order of 3/10/2019. My lord, all this, my lord, we have furnished before lordship only for clarification to clear the doubt. But the evidence of 66-70 of voter list that has been proved, and my lord, the notice indicates that her father's name is Muslimuddin. So they are admitting that I am the daughter of Muslimuddin. Then what is their evidence, my lord, that I am not the daughter of the Muslimuddin? I have claimed, my lord, I have claimed my statement. They have to deny, my lord. And in this connection, my lord, I am also relying on another judgment of this honorable court in the case of Abdul Khalek versus Union of India, reported as 2013 1 GLT 941, my lord. 2013 1 GLT 941, my lord. Paragraph 6 and 9 is relevant, my lord. Paragraph 6, may I read out, my lord?
Just a minute.
Lordship got it?
Trying to get it.
Paragraph 6. I have the copy, my lord.
We have.
System will develop. I have seen in the Supreme Court, my lord, the advocates are with tablet, judges are also with tablet, no file.
E-code.
E-code, sir.
Yes. Para 6 and 9.
Para 6 and 9.
Yes.
It has been contacted by the learned counsel for the appellant that it is evident from the deposition of witness number 1, 3, and 1, 2, and 3, as well as Exhibit Q, voter list, that Abdul Wahab was the grandfather of the appellant, who was a voter in respect of Samaguri Legislative Assembly constituency, whose name appeared in the voter list pertaining to the year 1965, and hence, according to the Learned Council, the the tribunal ought to have or not to have opined that the petitioner is not an Indian. More so, when the positive statement of the appellant and his witnesses have not been challenged by the state by way of cross-examination. But they have not challenged, my lord. Whatever I have deposed, my lord, there may be here and there some mistake. They have not challenged, my lord. Then paragraph 9, the appellant in his deposition in categorical term has stated that the grandfather name is Abdul Wahab, whose name appears in the voter list of the year 1965 pertaining to Samaguri Legislative Assembly constituency. The witness number 2 and 3, namely the Gaura and the villagers of Diju Basti village, has proved the said voter list, which is marked as Exhibit Q. Witness number 3 has also stated that Abdul Wahab is the grandfather of the appellant. Such statement of the witnesses have not been challenged by the state by way of cross-examination. Witness number 2, the Gaura of the Diju Basti, however, has stated that though the name of one Abdul Wahab appears in the voter list of 1965 pertaining to Samaguri Legislative Assembly constituency, he, however, does not know who is Abdul Wahab and whether he is the grandfather of the appellant. Witness number 1 and 3, having categorically stated that Abdul Wahab is the grandfather of the appellant, such evidence of witness number 2 would not demolish the case of the appellant as revealed from the evidence adduced by him, more so when there was no cross-examination of any of the witnesses examined, my lord. So, my lord, one witness has made some observation, my lord, against the evidence of the witness number 1 and 3. That has been turned down by this honorable court and accepted because the other side has not made any denial cross-examination. So, my lord, I want to mention, my lord, the inquiry report. Inquiry report, whatever they have done, that is not in proper manner. I have gone through the records, my lord. I have seen the statement of the witnesses are recorded, but no signature, which is to be done as per the full branch judgment in paragraph 97. Well, what has prevented them to take signature, my lord? That has not been taken. So this is one part of the irregularity in the case, my lord. My lord, the Muslim order judgment is also guideline is also not followed. So, my lord, there is some mechanical reference. So, when there is mechanical reference, the opinion is not good, my lord. It should be set aside and interfered, my lord. And my evidence is not demolished, my lord, in any way. Rather, the tribunal has given wrong interpretation, wrong calculation of the age and discarded, my lord. With this, my lord, I now, if lordship allow me, I may also submit a written argument also.
Mr. Secretary, come to page number 142. The sale deed of your land,
My lord.
right?
My lord.
Read from the first line very slowly.
बरोबर मोहम्मद अब्दुल कादेर पिता मृत मुजफ्फर आলী জাতি মুসলমান পেশা কৃষস্তিক মৌজা রামদিয়া সাং খপনিকুচি থানা হাজো জেলা বরগুনা লিখিত 1 নং মুসলিম উদ্দিন পিতা দবির উদ্দিন 2 নং মোহাম্মদ সূর্য মোল্লা পিতা মইজুদ্দিন মোল্লা, 3 নম্বর মোহাম্মদ সৈয়দ আলী, 4 নম্বর সোহরাব আলী, 4 নম্বর নাবালক অধ্যক্ষে নিজ মারা মোসাম্মদ সকিনা বেগম, নিজ মাতা সকিনা বেগম, স্বামী মৃত হাফিজউদ্দিন, মোসাম্মদ সকিনা বেগম, স্বামী মোহাম্মদ হাফিজউদ্দিন, নিজ পক্ষে উভয়ের জাতি মুসলমান পেশা
Now go slowly.
মুজা
জাতি
রামদিয়া,
মুসলমান, পেশা গৃহস্থী,
মুজা
মুজা
রামদিয়া,
রামদিয়া,
ফাং
ফাং,
কমনিকুসি,
Koponicusi, Thana, Hajo, Jila, Kamrup.
my lord.
So this Muslimuddin, son of Jabiruddin, was a resident of village Koponicusi,
My lord,
Moja Ramdia,
my lord,
police station Hajo, district Kamrup. Where it was mentioned by
my
the
lord.
Gaon
Nothing has been mentioned in the WS, my lord. But, my lord, during the period of disturbance in the BTAD area, they stayed for a short period and
No.
acquired
which
land
year
and
you-
again sold it out. And,
Which year you have sold it?
my lord, this is of,
Which year you have sold it?
this deed is of 1975, my lord.
7th of January 1975. When did you purchase?
My lord.
When did you purchase?
My lord, my lord,
Petitioner is
that
very
has not
intelligent.
been, lordship may not rely on their judgment or on the land documents, but
Petitioner-
detail has not been furnished, my lord. That
Petitioner
is
is very intelligent. Very intelligent. Credit goes to her. Yes, Mr. Pai. Do you have any other judgments to cite?
my lord, my lord,
Yes.
I have given, my lord,
Okay.
Hmm?
Mr. Pang.
Madam.
Mr. Sikder has tried his best
Yes.
by placing the relevant judgments and also the documents. Leaving aside the additional affidavit and other documents to establish the fact that in 1970, the projected parents of the petitioner was a resident of village Mesapara. Thereafter, they shifted to Holland. It is also in the evidence of the proceeding, the village element of Holongpara, as well as one of his niece from her husband's side, right? That they used to reside in Holongpara. She got married with this. In this background, the claim of the prosecutor is that when these evidence are available before the tribunal did not consider it in proper perspective. Right? So this order of the tribunal appointing the petitioner to be foreigner on the basis of the material evidence is bad in law. We've been repeating constantly, we are sitting here for session.
Yes.
Now Mr. Sikder tried the level based to establish why this order is bad in law. So now run it up to you.
Yes. My lord, first of all, before going to other aspect, my lord, only as my learned friend was, senior friend was arguing 2 points, my lord, I have to give reply on that 2 points. First of all, with regard to para 97 of the, my lord, the Muslim Mandal, that fair trial was not done. It is not that, my lord, it is mandatory that the investigation officer should take
Two
that.
things Mr. Sikdar has said.
Yes,
Written statement not mandatory,
yes, I'll
but
come to,
evidence is
yes,
mandatory.
yes,
Only by the evidence. Also place the judgment of 2005 to the LT. That kind of evidence is also not required to prove the nationality.
my lord, I'm coming to that.
So keep these things in mind while
Yes.
making your argument.
First of all, my lord, the para 97 has says just I'm reading out the line. The investigation officer, as far as practicable, shall also obtain the signature or thumb impression of the person against whom such investigation is initiated. As far as practicable, against thumb impression or signature should be taken, may be taken, my lord. It is not that it should be taken. As far as practicable, should be taken, may be taken, the signature or thumb impression of the person against whom such investigation is initiated, not from the, my lord, witnesses or whoever it may be. After recording the statement, if any, provided he makes himself available for that purpose. So it is not mandatory, my lord. So it doesn't make the investigation.
মোটা কিতাপ আছে সাইডৰ ফালে পঠালি কনষ্টিটিউচনেল ল সাইডৰ ফালে বনোৱা কিতাপখন
So it doesn't make the, my lord, investigation or the inquiry bad. It's only as far as practicable, if it can be, it may be taken. And even in last part, it is again since, say, if any, provided he makes himself available for that purpose. So, my lord, it is not that it is mandatory to take the signature of the person after taking the my lord, statement at the time of inquiry. So, inquiry part, as my learned senior friend asked you, it is clear from this para 97 itself, my lord. Secondly, my lord, my learned senior friend also argued, my lord, one point, and I'm coming to the, my lord, small points with my learned friend senior friend, that I may forget those points, my lord, because he said, my lord, that in the notice, the father name has been written as so and so. So that shows and that proves that she is this daughter of that person. That issue has come up before this honorable court, my lord. And this honorable court has settled that position. This honorable court has settled that position. I want to rely that judgment, my lord, on that effect, my lord. That is WPC 391617 of 2016, my lord.
WPC
3917 of 2016. Rupali Bibi, my lord.
Three 3917.
Yes, ma'am. 3917 of 16. 2001. 16.
Decided on 13th of
Yes, 13th of February 2018, my lord. Para 14, my lord, the portion of the para 14, my lord. May I read it?
just para
Para 14, my lord. 14. Para 14, may I read, my lord? Before proceeding further, we may deal with the argument of learned counsel for the petitioner that mentioning of the petitioner as daughter of Akbar Ali Bepari in the notice issued by the tribunal itself was proof of fact of such relationship. We are afraid we can accept such an unacceptable argument advanced on behalf of the petitioner. Marking of notice to a person, mentioning therein the person to be the son of or daughter of some other persons, cannot be construed as the proof of the fact that notice is the son or daughter of the person. This is mentioned in the notice only for the purpose of identification of the notice and for service of notice. Certainly, it cannot be taken as proof of the notice being son or daughter of the person. This information can be obtained from the noticee herself or from some other documents or sources, but there is no proof of the fact. This is particularly so in the context of the Section 9 of the Foreigners Act 1946, which has been explained in detail by the Supreme Court as above. Even then, we may briefly examine the relevant provisions of the Evidence Act 1872. Section 3 of the Evidence Act is the interpretation clause. Fact has been defined to mean and include anything, state of things, or relation of things capable of being perceived by sense, and two, any mental condition of which any person is conscious. A fact is said to be relevant to another when the fact is connected with the other to any of the ways referred to the act relating to relevancy of the fact. The expression fact in issue has been defined to mean and include any fact from which either by itself or in connection with other facts, the existence, non-existence, nature, or extent of any right, liability, or disability asserted or denied in any suit or proceeding necessarily follows. Under Section 3 of the Evidence Act, evidence means and includes oral evidence and documentary evidence. All statement which the court permits or requires to be made before it by witness in relation to matter of fact under inquiry would come within the ambit of the oral evidence. On the other hand, all documents, including electronic records produced by the inspection of the court, are documentary evidence. The word proof has a different contention. In the context of the Evidence Act, a fact is said to be proved when after considering the material matters before it, court either believes it to be exist or considers its existence so probable that a prudent man ought, under the circumstance of the particular case, act upon the supposition that it is exist. A fact is said to be disproved when, after considering the matters before it, court either believe that it does not exist or considers it non-existence, so probable that prudent man ought, under the circumstance of the particular case, to act upon the supposition that it doesn't exist. A fact is said to be not proved when it is either proved, neither proved, nor disproved. Well, they properly explain what is evidence and other. But in para 14, it is clearly said that it cannot be accepted as evidence of that fact. This is because, my lord, while initiating these proceedings, there is an investigation. An investigation, my lord, the petitioner, the proceedings are questioned by the investigation officer. The informations are given by the proceedings at the time of my lord inquiry. So whatever information he has given to the inquiry, that is recorded in the inquiry forms. So if a person gives his name, intentionally gives his name in a different father's name in a different manner or in a different name manner, how can it be said that it is his father's is that person itself? So that fact has to be proved. So giving only not mentioning the father's name as so and so in the notice itself is not enough to prove that the person is the father of that particular person. So this issue has been settled, my lord. This is no more integrity. And regarding my lord WS, whether WS is a mandatory or not, my learned senior friend has relied on the most this my lord, the Hyder Ali was relied on. In fact, in that case, my lord, the Hyder Ali is relied on.
Yes.
And Hyder Ali, my lord, it is. Hyder Ali. Yes. Para 29 of the Hyder Ali was relied on by my lord senior friend. The 2023 GLT my lord 85. Here the observation was my lord. From the above, what is important to note that the Foreigners Tribunal constituted under the Foreigners Tribunal Order 1965 merely provides a a reasonable opportunity for making a
Hyder Ali is 4116. 1818, public 19.
1818 of 2019, my lord.
Hyder Ali 2000
21
3GLT.
3GLT 85, my lord. It was disposed of, my lord, on 30/10/20 30/03/21, my lord.
Yes, ma'am. ঠিক এটা কেস বেয়া নহয় ছয়টা বিভাগত এভিডেন্স দৰ্শনৰ পাতিছিল
Yes. From the above, what is important to note is that Foreigners Tribunal constituted under the Foreigners Tribunal under 1964 merely provide a procedure, a reasonable opportunity for making a representation and producing evidence in support of his case before the tribunal. And as such, normally the rules of pleading, including that of written statement, as provided under CPC, are not applicable. This is the provision, my lord. This is the point my lord senior friend is relying, that the written statement provided under CPC are not applicable. CPC, as a corollary principle contained in the CPC relating to scope of written statement and limited plus, therefore cannot be strictly applied in the proceeding before the tribunal to the principles as may generally be applied. Well, yes, this point was decided here in this honorable court by this honorable court on my lord 33/2021. But there are judgment of the honorable court which are not taken considered, my lord, while passing this judgment. There are numbers of judgment where this honorable court has decided and my lord, and said that written statement is the basic, my lord, pleadings in the foreigner's case, and on the basis of that only, the tribunal the proceeding has to prove his case. And those were not considered. I like to rely, my lord, because, my lord, this is
Just a minute.
Preparing this input charge.
Mr. Parang,
My lord.
kindly read order 3-1 of the 1964 order.
Yes.
Got it?
Order 3-1, my lord. Yes. Order 3-1, my lord. 3. Procedure for disposal of question. The tribunal shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged to be foreigner and give him reasonable opportunity of making a representation and producing evidence in support of his case, and after considering such evidence as may be produced and after hearing such person as may be desired to be heard, the tribunal shall submit its opinion to the officer or authority specified in behalf in the order of reference. This is 3-1, my lord.
Read 8.
3-8. 3-8 says, my lord, the foreigners tribunal shall give the proceedee 10 days time to give reply to the so-called notice and for the 10 days time to produce evidence in support of his or her case.
I know.
So,
First,
my lord, as your lordship has rightly pointed out, my lord, two things your lordship has to consider here, both the 3-1 and 3-8, my lord.
That is indeed very much in the,
My lord, Foreigners Tribunal Order 1964.
for that purpose,
Yes. Two things, my lord. First of all, reply. Then second thing is evidence.
also you can read, because do not reliable here, because 64 orders will be applicable. Read 2006 order.
2006 order. 3, my lord.
3.
The tribunal, upon receipt of the reference under subparagraph 3, subparagraph 1 of the paragraph 2, shall consider whether there is sufficient ground for proceeding, and if the tribunal is satisfied that basic facts are prima facie established, it shall serve on the person to whom the question relates a copy of the main grounds on which he is alleged to be a foreigner and give him a reasonable opportunity of making a representation and producing evidence in support of his case, and after considering such evidence as may be produced and after hearing such person as may desire to hear to be heard, the tribunal shall submit its opinion to the officer or authority specified in this behalf on the other order or reference.
So notice is a so-called.
Notice
In
is
the
a so-called
notice, there is a specific provision that you should shall you reply
reply.
within such and such.
Yes,
a-
madam. Reply within 10 days.
Now that reply, that is the show cause and a reasonable representation
Yes,
to prove his case
case.
regarding or her case regarding the nationality.
Yes,
And that has to be proved along with the evidence.
evidence. That is the only point, my lord, that the nomenclature may be in the name of written statement or maybe in the name of, my lord, reply. But it should be public.
A written
Furnished.
statement.
Yes,
A statement should be allowed to give the file. That's
in
what
the,
is the order 64 rule 3,
yes,
one particularly says.
yes. Ma'am.
Next.
So my contention is that, my lord, this honorable court has also affirmed the same provision, my lord, of the Foreigners Tribunal Order 1964. That is, I like to rely, my lord, the the 2017 4 GLR 295.
Hmm? 2017 4 GLR 295.
Yes, madam.
Just a minute. What is the party's name?
But his name is Saru Sheikh, my lord. Saru Sheikh.
Can you-
WPC number 3662 of 2016, my lord. Saru Sheikh, WPC number 3662 of 2016. There are numbers of judgment to this effect. Just I'm pointing out to three, my lord.
Oh, dear. Yes, which para you want to?
Para 13 and 14. Having,
Para 13 and 14.
yes, madam. Having noticed the above background, madam, let us start.
The equivalent citation is 2017 4 GLJ.
4GL.
138. It hasn't been reported in GLT.
Yes, ma'am. Probably. This is argued by my learned senior friend of AR Sikdar. Yes.
Para 13, 14.
Yes. Sorry. Para 13 and 14 is my lord. Para 13 says, having noticed the above background, we may now examine the stand taken by the petitioner before the tribunal in the written statement. It goes without saying that in a proceeding before foreigners tribunal, written statement is the basic statement of defense of a proceeding. Having regard to the mandate of Section 106 of the Evidence Act and Section 9 of the Foreigners Act, it is incumbent upon the proceeding to disclose all such facts which are specifically within his or her knowledge, having a material bearing on his claim to be a citizen of India at the first instance itself. That is in the written statement. Such facts are thereafter required to be proved by adducing cogent and reliable evidence. That is the point, my lord. Failure to disclose such material facts may lead to drawing of adverse inference against the proceeding. In the written statement, filed, petitioner did not disclose his date of year or birth. Consequently, there was no disclosure regarding his age. He also did not disclose the plea where he was born. All that he disclosed was that his father's name was let so-and-so. Petitioner was recorded as voter in the voter list of 85, 96, 2008 in respect of Abhayapuri South constituency. These are facts, my lord, but the principle is the first part, my lord. Then para 14 says, my lord, again, such a written statement is wholly inadequate to make out a case of citizenship. It is also tried that a party is bound by his own pleadings in the written statement and he cannot traverse beyond the pleadings. We disclosed his age for the first, Be that as it may, in his evidence in the SIP recorded in 31/2016, petitioner discloses as for the first time as 56 years. These are my facts, but the principles are there. Secondly, my lord, another judgment, it is again of 2017, my lord. 2017 3 GLR 820.
Eight four zero.
820. 820, by 2017 3 GLR 820, Aisha Khatun, my lord. Aisha Khatun versus Union of India, WPC number 2145 of 2012.
2145.
2145 of 2012, my lord.
Equivalent citation is 2017 3 GLJ 490. Yes, which para?
Para 12, my lord.
Yes, kindly read.
Yes. Written statement submitted by a noticee facing a proceeding under the Foreigners Act 1946, read with Foreigners Tribunal Order 1964, is the foundation of his or her defense. Since citizenship of the noticee is questioned, the noticee should come out with all material facts within his or her exclusive knowledge in terms of Section 9 of the Foreigners Act 1946 and disclose them in the written statement. The avertments made in the written statement are thereafter required to be proved by adducing cogent and reliable evidence. Failure to disclose material particulars in the written statement by itself will raise a serious question make on the citizenship status of the noticee. So this is, my lord, just another one, my lord. Another judgment, my lord, there are numbers of judgment, but I relate to only one more judgment, my lord, because it will. That is 2017 2 GLT 974, my lord.
Aksara Khatun.
Yes, my lord, Dr. There are also para 12, my lord.
And 2 GLT. Yes.
Para 12.
Para 12. It is all on the same line, my lord. From this written statement, it is evident that petitioner did not disclose basic material facts which are within his specific knowledge. Petitioner did not say when he was born. Consequently, there was no mention about her age. She remained completely silent as regard to her mother as well as about her brother and sister. Though she mentioned Mohammed so-and-so as her husband, she did not mention when she got married and whether post-marriage she had any children. When citizenship is being questioned, that provides that one has to disclose all material facts which are within his special knowledge to prima facie establish his citizenship of India, which are thereafter required to be proved by adducing cogent and reliable evidence. Failure to disclose such material facts at the first instance itself, that is in the written statement, which is the basic defense statement of the proceeding, may lead to drawing of adverse inference against the proceeding. Moreover, it is well settled proposition that a party cannot revert beyond the pleadings. What is pleaded can only be proved and not something which is not pleaded. So this is with regard to WS, my lord, and up to what extent the proceeding has to prove, my lord. But these aspects were not considered in my lord.
I will give my lord
You
a
come back
reply
at
short second.
Come back.
Yes.
That just meant the federally, my lord.
Hmm.
The earlier decisions of this honorable court, where the points, law points was settled, the written statement is a necessary part in the in the proceeding under foreigners tribunal, and there my lord, they have to plead their whole material facts in the written statement. Those were not considered. So in that aspect of the matter, my lord, it cannot be accepted as a valid law for not considering the agreement. So that
It is not a valid law,
yes,
but
yes,
thing is this,
yes.
we'll see to that. Okay.
So now with the facts, that is, my lord, here in this case, my lord, your lordship will find there is in fact all these legal points may not be necessary because only one point is there, my lord. The petitioner has placed his father the documents of 1966 and 70 projected to be her father,
No,
66 and 70.
entire claim of Mr. Sikdar on behalf of the petitioner is that the tribunal, without considering the evidence adduced by the petitioner in proper perspective, have passed that order.
No.
Did not discuss the issues therein properly because the evidence was there before the tribunal, because what the Mr. Sikdar has placed is the, if you go to that judgment, he has particularly highlighted few issues.
Yes, my lord. No, to that, I'm coming to that point, my lord.
You
My lord,
go
my-
on that,
My learned senior friend has said, good, your lordship may kindly see six paragraphs.
particularly
Page
4, 5 and
64.
6.
Yes, page 64, my lord.
Hmm.
Page 64, the appreciation of
Application of
evidence. My lord, my learned senior friend is arguing that point only.
Hmm.
That in what is the recording of the my lord, appreciation of the evidence by the tribunal.
Hmm.
In fact, my submission is that, my lord, if even though we appreciate the evidence, at now, my lord, we cannot go for appreciation of evidence as because we are in certiorari. The court, my lord,
You can
yes.
also look into the, if in a wrong such,
My lord, this wrong,
Appreciation.
this is not a wrong appreciation, my lord. This is just a clerical mistake, mistake. My learned friend, senior friend is emphasis on that point, my lord. That your lordship may kindly see what is at very outset, para 6, my lord, page 64, I'm reading again. It is noticed that exhibit H, which is exhibited by Proceeding NRC 1951. On a close scrutiny, the same appreciated a photocopy of NRCs. It is a photocopy of the NRC. It is a admitted position, my lord. It is a photocopy of the NRC. And but the validity of the photocopy as a secondary evidence cannot come, my lord. So this being the position, the exhibit H cannot be accepted as a proper document. With regard to my lord, NRC cannot be accepted as a but evidence for the purpose of citizenship. In fact, NRC document is not accepted as evidence. That is an admitted position and a settled position. Secondly, my lord, it is a certificate. It is not a certified copy. It is a photocopy of the certified copy. So that has to be proved. The original is not produced. That is, in fact, the record there, the record also it is certified. It is Xerox copy.
first of all, this has been issued by a political party.
I'm not coming to that one, my lord.
How
even-
can it be considered?
Yes.
If it is an NRC document, See, the recent judgment of the apex,
Yes, ma'am.
para 54, I think.
Yes, ma'am.
Even it is the subject matter is incorrect by
Yes, my
the
lord.
tribunal.
We have no,
It is clear, but here, Mr. Secretary, here also you see, this is an NRC entry certificate. Name of Muslim, Muslimuddin. Son of Rubiuddin. Age 16 years. In 1951. Appears in the NRC in village Katalagaon, Moja Bhavanipur, holding number something, house number 8, in police station Borpeta of district Kamrup. Name Muslimuddin, Hafizuddin, Sukurjan, and one Sakhija. Who have issued it? Borpeta District Congress Committee Assam, President. When it was issued, 25th of September 1966. NRC, first of all, have to be issued, as you know by whom. And accepting that particular authority, there is no other authority can issue such NRC. First of all, this document is not by that authority.
yes, exhibit is.
Secondly, it is when issued by the President of District Congress Committee. What value it will have? You are aware because you've been doing all
Yes,
these
ma'am.
cases. And thirdly, it relates to a Katalagaon village, who is the petition proceedee have never mentioned that her father and mother was at Katalagaon at any point of time. It was Mesapar. Now only you have.
That
opened the
has
records.
been, my lord,
So don't try to bring in this.
my lord,
documents for your
we are
sake,
not
because-
relying on that, my lord.
So-
It was rejected by the tribunal, not
So
considered.
that is why we are asking.
But
you whether
apart of
rightly
that,
or-
my lord,
rightly
we
or
have the-
rejected wrongly,
we have the legacy document, my lord.
that let
We have the
Mr.
legacy.
Yes.
let
Only
Mr.
point is, my lord, the member has signed it.
No, that is submitted, that is exhibited, so it is.
Signing.
It's signed.
Signing it will not give a proof.
My
of
lord,
all.
document
That means
itself
it
is
is-
not
it is
security
exhibited.
documents, my lord. We are not on that, my lord.
Yes.
Don't bring
So
it.
he cannot.
Don't bring in those documents that may harm you.
That,
You may have enough of
yes, my lord.
documents,
Yes, my lord.
but you have the quality of the
Yes, my
document, not the quantity, as you know, so many judgments have said.
Is
So you should.
wrong guidance, my lord.
Anyway,
Yes.
yes.
My lord, so NRC is not accepted, my lord, for that purpose. Whatever
Then
purpose it
judgment
may-
shows.
Yes. During cross-examination, the proceedee DW1 has narrated the father as late Muslimuddin.
Where you are reading 6, huh?
That's six mane para 2, my lord, second para. Para 6, my lord, second para. During cross-examination, the proceedee DW has narrated that father of late Muslimuddin, son of late Dabiruddin, cast his vote in 1966, Exhibit D. There is no dispute on that, my lord. One Muslimuddin cast vote in 1966. And in the year 1970, Exhibit D, under 50 number Borpeta listed Mesapara in Exhibit D. Age of her father was 40 years in 1966. And that calculation, the tribunal committed mistake. That is difference of 2 years only, my lord. 2 years. And in the Exhibit E, the age was 44 years. And 44 years. That is 1970 minus 44 is 1934, date of birth. So, yes, my learned senior friend has argued this, my lord, this has been committed by the tribunal. My submission is that, my lord, even though we accept the petition of my lord, this person, Muslimuddin, was there and he was correctly, his date of birth is 1926 in the both, my lord, 1966 and 70. Even then, my lord, suppose we accept that the tribunal has committed, this is a clerical mistake that it may be committed, but does it sense any character of the opinion, my lord? It does not sense any character of the opinion. It will no way, my lord, prejudice the petitioner. Because, my lord, the next one, if we go, my lord, and in fact, this was not exhibited, the 1997 voter list, this was not exhibited by the petitioner, but it was brought later on the request of the And in exhibit G, his age was 91 years in 1997 minus 91. This is correct, my lord. So in that case, even though we accept it in my lord, the 1966 and 70, the Muslimuddin dead person who was there in 1966 and 70, he was born in 1926. And this person who was in voter list of 1997, his date of birth will be sometime in 1906. This is clear. There is no ambiguity in that, my lord. There is serious contradiction regarding date of birth of her father. This is the contradiction, 1906 and my lord 1926. 20 years contradiction. Thus, there is serious contradiction in regarding date of birth of her father. DW1 also stated that her grandfather's name is Dabiruddin, but in the voters list of 1997, her father's name was shown as Dabir. So Dabiruddin and Dabir is same person. That has to be proved. That is not true. Now, this is the only point my lord senior friend arguing that this is wrong. Apart from this, my lord, suppose we accept, my lord, that this Muslimuddin was there in 1966 and 70 in Mesapara village. Now, it is the petitioner who is to prove that this Muslimuddin of Mesapara is her father. Where is that proof? To prove that.
Right, Gaura certificate.
Yes, that is the only.
DW3,
Yes,
DW2.
that is the only Gaura certificate, and Gaura certificate, your lordship will find. What is the defect in Gaura certificate? Gaura certificate cannot be accepted for many reasons, my lord. First of all, my lord, the national emblem is there embossed on the top. Lordship will find Gaura certificate at my lord, page 32, my lord. Page 32 is the Gaura. This is the only document whereby the petitioner is trying to link herself to that Muslimuddin of my lord village Mesapara. Before going to this, my lord, it is from the evidence as well as my lord the written statement, my lord. Just before going to this, it is clear from the WS and evidence, my lord. The petitioner is, my lord, I'm just reading she has studied in WS with regard to her date of birth and my lord place of birth. The first part is my lord. Before going to my lord page 32, I'm coming to that page 32 later on, my lord. The lordship may kindly see page 16 in evidence, my lord WS. What he has studied in WS, she has studied. Whereas, my lord, page 16, my lord, in WS, the second party has said, the second party is a citizen of India by birth and permanent resident of village Kopanikusi, post office Suincho, Hazu district of Kamrup. Her marriage was solemnized with Ainul Khan, son of Nesar Khan, resident of above noted village Kopanikusi, as it about 35 years ago, till second party is remaining living at this address. Prior to the marriage, the second party used to live with her family in village Halengibari. In all along, she has said, my lord, she was residing at Halengibari prior to marriage at so-and-so in the district of Assam. So this is clear, my lord. She has said that she was living along with her parents at Halengibari. This is her positive statement. Secondly, the same thing, my lord, in evidence also she has stated the same. Evidence, my lord, evidence, page 33, written evidence. Evidence in affidavit, page 33, para 2, my lord. This is her positive statement that I am a citizen of India by birth and permanent resident of aforesaid localities. Prior to my marriage, I have grown up at village Halengibari, Moja, Halengibari, Bizni, PS, so-and-so, Assam, and I was born in village Mesapara, Moja Hauli, PS, Borpeta district, Assam. And my father, then my lord, she has said that she was grown up in Helengibari and only she was born in Belize, Mesapara. Now, my lord, the voter list of 1966 and 1970. 66, your lordship will find page 24. Page 24, it is, my lord, this is of Mesapara village of 1966. So in 1966, it is Mesapara village. And 1970, page 26, it is of Mesapara village of Muslimuddin. So these are the two voter lists, my lord, she produced before the tribunal. And 1985 voter list, page 28, this is of her own, and this is of Kopani Kusimala. Now, in WS, my lord, she has nowhere stated that she and her family and she was there in Mesapara prior to marriage, or she was born in Mesapara. Same contradictory statement in WS, written statement, in evidence, my lord. Written in evidence, she has said that she was grown up in Helengabari and she was born in Mesapara. But from 1970 to 1997, the petitioner could not produce any document of her parents that they were residing in, my lord, Mesapara, residing in Helengabari, where she was grown up. That evidence is nowhere there.
No, what do you want to say that this 85 voter list relates to Kopani Kusi?
Kopani Kusi. That is of the petitioner, my lord. Petitioner, as wife of, my lord,
I know.
Now,
You are saying that from 1970,
yes,
after 1970.
after 1970 till 1997, there is no document that, my lord, that the petitioner and her parents were residing at, my lord, Halangbari. And that, my lord, the Muslimuddin of Mesapara and the Muslimuddin of Mesapara and the projected father of the petitioner, whom the petitioner is saying is my lord, residing in Halangbari, is the same in one person. And in fact, existence of this father of the petitioner at Halangbari is not there. So only there, my lord, they are saying that the petitioner's father is Muslimuddin of Mesapara, but to that effect there is no evidence, because the petitioner has in WS not said that she was residing in Mesapara in any point of time, or she was born in Mesapara. Evidence she has contradicted that point in some extent, saying that, my lord, she was grown up in Halangbari but born in Mesapara. But there is no evidence to that effect that she was born in Mesapara. Well, para 26 of Sarbananda Sonowal has clearly said, my lord, what evidence is necessary? Evidence of date of birth, evidence of place of birth.
Why you are saying that?
Because, my lord, the petitioner has not, neither in WS nor in evidence said when did petitioner born, my lord. He has not given any evidence of his date of birth. Neither he has given any evidence of his place of birth, my lord. He has not given any evidence of place of birth. In fact, he has contradicted with regard to his place of birth. In WS, he has said his date of birth is, the place of birth is, my lord, Helengabari. He has born and he was, my lord, as in WS, your lordship will find para 2. Again, I am relying on that. That second part is
Born in Mesapara.
Yes. No. WS, my lord, she has said second part is a citizen of a by birth and permanently residing at so and so and so and so. Assam, her marriage was solemnized. Ainul Khatun, resident at about so and so, so and so. Till then, my lord. Till then, second part is remain living at his address prior to his marriage. Second party used to live with her family at village Halangabari. Post office, Kasamari, Gaza, so and so, and second party was born at village Mespara, village so and so, yes, so and so. So he has stated, but there is no evidence to that effect. My point is, my lord,
What evidence you are looking for?
no, whether, my lord, two evidence, my lord. First of all, place of birth and date of birth. What is the evidence they has given? No evidence at all, my lord. No evidence at all. It is their duty to give evidence of their date of birth and place of birth. They have not given any evidence of place of birth and date of birth. Only statement is given there in WSL and evidence in evidence. And now it was their duty to prove that this Malat Muslimuddin of Mesapara is the father of the petitioner. What evidence they have brought? To that effect, they have brought only that Gaubra certificate. And Gaubra certificate, what says, Malat, page 32? Your Lordship may now kindly see the page 32. What is the Gaubra certificate? Gaubra certificate was issued by some Utpal Ramsiari of village, Putapara village. He is neither of Mesapara, nor of Malat, this Malat, what would be it, please? Halangibari or Mespara. Not of a single village. He is a Gaubura of Putapara village, Malat. He is Gaubura, resident of Putapara. What he has said, Yadara Pramanpatra of Dia Hoise Srimati Lalbhanu, Pita Muslimuddin, Gaon Halabari, Patal Ghat, so and so, Patasar Kusi. Here village is Halangbari, my lord. Morpeta Uporokto Byaktijoni Mor Gaon, Lator, Halangbari Gaon look hoy. Like my Sini Pound, Sobat Sritofal, Moiter Bobichat, Mongol Kamanipuri. Ukto Swalizoni, Kuponikosi Gaon, Nasir Khanor Putro, Ainal Khanor Logot Biahua Hotto. উল্লেখ থাকে যে তাই দেউতাকৰ মেছাপাৰা গাঁৱৰ খণ্ড নং ইমান ঘৰ নং ইমান ক্ৰমিক নং ইমান 1964 চনৰ ভোটাৰ তালিকাত নাম থকা দেখা যায় on what basis he has given this certificate now my lord let us first of all with regard to this documents matter this document is not an admissible evidence document because the national emblem is my lord embossed in the top of the document so it cannot be accepted as a valid piece of evidence my lord. This is inadmissible document. Secondly, my lord, the Gaubura in his evidence on page 47 is the evidence of the Gaubura, my lord. What he has said, my lord, mostly I'm relying on only one line. He has said that, my lord. Let us read the entire evidence, my lord. He is aged about 28 years. So his personal knowledge will go, my lord, at least, at best 28 years prior to 2016, my lord. It cannot go beyond that, my lord. Whatever evidence he will give, then it will be hearsay prior to that. It is not his personal, it cannot be of his personal knowledge. That aspect we have to remember, my lord. So what he has said, মই 2011 চনত গাঁওবুঢ়া হিচাপে নিযুক্তি পাওঁ মোৰ তিনিখন ৰেভিনিউ ভিলেজ উলংবাৰী কঠাল পুখুৰীঘাট খুটপাৰা মই প্ৰসিদ্ধি লালবানু বেগমক চিনি পাওঁ he is not a resident গাঁওবুঢ়া of Mesapara or any other village উলংবাৰী কাঠপুৰী কঠালপুৰী আৰু খুটপাৰা মই প্ৰসিদ্ধি লালবানু বেগমক চিনি পাওঁ মই গাঁওবুঢ়া হোৱাৰ আগৰ পৰাই চিনি পাওঁ কিন্তু তেওঁ কেতিয়া বিয়া হয় মই নাজানো she has given a certificate that she got married to so and so but he does not know when she got married প্ৰসিদ্ধিৰ ঘৰ হলংবাৰী গাঁৱত মেছপাৰা গাঁৱৰ খনৰ প্ৰসিদ্ধি স্বামীৰ বসবাস কৰা গাঁও বুলি মই শুনিছো মেছপাৰা গাঁওখন প্ৰসিদ্ধি স্বামীৰ বসবাস কৰা গাঁও বুলি মই শুনিছো মই দিয়া প্ৰমাণপত্ৰখনত সংলগ্ন হৈ যিখন ফটো আছে তাত কাৰো নাম লিখা নাই আৰু মোৰ সহি নাই মই দিয়া প্ৰমাণপত্ৰখনত কোনো ক্ৰমিক নম্বৰ নাই মই প্ৰমাণপত্ৰ দিয়া সময়ত কোনো ক্ৰমিক নম্বৰ নিদিও মোৰ লাটত লালবানু নামৰ অইন কোনো তিৰোতা নাই মই প্ৰচিডিং চাৰ্টিফিকেটখন দিওঁ যদিও আজি মোৰ হাতত কোনো তথ্য নাই মানে he has no document at all even though he issued that certificate
So is not document, more materials নাই.
no materials আজি মোৰ হাতত কোনো তথ্য নাই লালবানু so other part I'm skipping even though my lord that he has said that my lord মোৰ লাতত লালবানু নামৰ কোনো অন্য তিৰোতা নাই as your lordship has already pointed out in 1997 voter list there are other Lalbanu also but because I'm not going to that aspect also even now my lord he has clearly said that he has no materials with him at the time of giving this evidence
So give regarding the issuance of the certificate.
Yes.
He doesn't have any material.
He
That's
doesn't
what
have
said.
many materials. So it is, my lord, it is settled position of law. The Gaonbura, in fact, number 2 points, 3 points, my lord. First of all, Gaonbura has this document, Gaonbura certificate is not admissible for this reason itself that the national emblem is embossed on the top of this certificate. I'll, my lord, rely on the judgments that my lord, I'll give these citations. Then, my lord, secondly, even the Gaonbura is not authorized to issue such kind of certificate to any person under the Assam Land Revenue Regulation 1886. That is the second point with regard to this Gaonbura certificate. Thirdly, my lord, that the certificate was issued without any record, without on the basis, not issued on the basis of any contemporaneous record, and without making any inquiry to that effect. So the only link document is this Gaonbura certificate. And if it goes for these 3 reasons, my lord, there is no other link document of the petitioner to link herself to Muslimuddin of Mesapara of 1966 and 70.
You are saying document.
Yes.
What about the evidence of?
No, in fact, no evidence, my lord. Other oral evidence, sir, there oral evidence, my lord, oral evidence the petitioner has. Oral evidence he has brought, my lord. First of all, he brought 2 or evidence, 3 my lord witnesses, petitioner himself, second party himself, then 1 projected brother, and the my lord, projected brother, 1 Gaonbura and 1
Niece.
Niece. Nephew.
From his, from her
Yes, ma'am.
in-laws side.
So the my lord, evidence of Gaonbura, as your lordship has seen, it cannot be accepted even though for the purpose of oral evidence, because he was only 22 years at the time of giving the evidence. So his personal knowledge, my lord, his personal knowledge cannot go beyond his age, my lord. It can be at least 22 years, up to 22 years. It can go back up to 22 years, not more than that. And if we go back, my lord, 22 years from 2016, it will be sometime 92, 93, 94 from 2016. So his personal knowledge can be, if we accept from date of his born day also, my lord, it will be from 1992 only. Cannot go beyond that, 1992, 93. So a person who is just 22 years of age, he will give evidence that this person is residing in India or Assam prior to 1971, cannot be accepted. And he has not given evidence on the basis of any record. Had it been given on the basis of some record, we could accept it, my lord. So his oral evidence cannot be accepted for that purpose. And even though he gives some evidence of prior to that, it will be hearsay evidence. It is not, it will be not direct evidence.
Yes.
And secondly, my lord, regarding oral evidence, this honorable court has time and again said in numbers of judgments that the oral evidence, if it doesn't support the corroborate the other documentary evidence, it cannot be accepted as a valid piece of evidence for the purpose of.
Mr. Pang,
My lord.
what Mr. Sikdar was pointing out with regard to the evidence of the Gambura, that he knows her well.
Yes, ma'am.
And then,
He knows us well, but he doesn't know the brother of the petitioner.
no, that is different issue, and at this point, we are not coming on that. A person, why the Gambura may not know if she is regularly visiting her parental home?
My lord, he may know, but that is hearsay evidence.
Say that.
Yes, he may know because
It is the petitioners, since the petitioners'
No,
parents,
my lord.
as per her, have shifted from
first of
Meswara
all, we
to
have,
this particular village
yes,
and Holongibari, right?
yes, ma'am.
So, it is possible that he can, she will be visiting her parental home. And that way, he might know her.
That is true, my lord. And sometimes
case,
he may
what
know
will
that, but it doesn't mean that she is the daughter of that person, daughter of the petitioner. That has to be proved, my
That
lord.
is his personal knowledge.
Personal knowledge. That is his personal knowledge. But this honorable court has again said, my lord, claiming that he is my father is not enough. A person's name in the voter list, and I'm claiming that that is my father, that is not enough. That has to be proved. My lord, that is proved in the matter, that is settled by this honorable court and said in numbers of cases it is said, latestly, my lord, in last recent it is said, claiming will not do, my lord. Claiming that he is my father, his name is in the voter list, and I'm claiming that he is my father, that will not do. That has to be proved by bringing some other materials that he is my father. Because his name is there in the voter list. He is a citizen. Muslim Uddin is a citizen. But whether that Muslim Uddin is her father or not, that will have to prove by bringing some other materials.
Now, what about the finding of the tribunal regarding this evidence of in her opinion?
Then we have to go back to para 64, page 64 again.
64, yes.
DW1 proceeded state in her written statement that as well as in her evidence in SIF, the last para, my lord, I'm reading. SIF, that she used to cast her vote since 1985 at village Khopanikusi, but courageously enough, she has submitted only voter list of 1985 under so-and-so in the district of Kamrup. The reason as to why she has not submitted such voter list of other years cannot be clearly understood. Another important point, as stated by DW1, proceeding para 8 of her evidence in SIF, that the parents had shifted from village so-and-so, village Mesapara, Borpeta district to village Halangibari, Borpeta district in the year 1970-75. That is about 40-45 years ago. Why her parents had shifted from so-and-so is not mentioned by said proceeding. In this regard, proceeding has not submitted any documents, but has only submitted the voter list of 1997 of village Halangibari. Although the proceeding has stated that her parents had shifted to the village Halangibari in the year 1970-75. She has not submitted the voter list of village Halangibari for other years, cannot reasonably be understood. But it is not found from the evidence of DW 2 and 3 that the father of the proceeding had shifted to village Halangibari, and it is only a plea made by DW in her evidence. So, for this reason, my lord, in this regard, for this reason, the tribunal has not considered the evidence of DW 2 and 3. That is the main point, my lord. Whether the Muslim Uddin who was there in Mesapara in 1966 and 70 shifted to Halangibari in between, and whether that Muslim Uddin is the father of the petitioner or not. And that in that point, DW 2 and 3 has not said, nowhere stated that mother Halangi, that person, Muslimuddin had shifted to village Halangibari in any point of time. That evidence is the DW 2 and 3 has not given any evidence to that effect. My lord, these are opinion to be passed by the tribunal. It is not necessary that each and every aspect has to be discussed, my. These are not judgment like, my
Okay.
lord. And
Right, then,
my lord, your lordship may kindly just one aspect, my lord, one thing, my lord, I was to rely on that judgment. That is WPC, my lord. 2376 of 70 of 2023. 2370 of 2023, Aziz Mia decided on 9/6/23, 09/06/2023. This is recent judgment on this matter. There are other judgments also.
this, let us complain by one.
Yes,
Because since the opinion of the tribunal is in the challenge.
yes. So the tribunal has pointed out, my lord. Then your lordship may kindly see what evidence the DW 2 and 3 has given with regard to shifting of the, my lord, the parents. Because if shifting is not proved, my lord, it cannot be said that they are the same person. DW2 page 47, my lord, cross. And page 42 is the written evidence, my lord. Evidence in affidavit. Sri Ram Utpal Ramsari, Gambura, so. I am a citizen of India by birth and permanent resident of the aforesaid locality, and I am remaining now in Gambura, in the above address, noted address. That in the above case, I said that I know second party since 19-20 years. So his knowledge is from 19-20 years. I have got the charge of Gambura about 5 years ago. Prior to me, my father was the Gambura of this village. That second party's father name is late Muslimuddin and her mother's name is Shukurjan Nessa. I know second party is living in village Puponikusi, Post PS Hojai, District Kamrup, Real Assam, and she is casting vote in the address. That all the contents made in this evidence in chief on affidavit are true to the best of my knowledge and belief. There is no evidence at all or statement at all given by the Malad Gambura, DW2, who is the father and where the father is residing, and whether this Muslimuddin of this Malad Mosapara and shifted to any other place after 1970. Or he is the same and one person whom the petitioner is relying on. Then DW3, my lord. In pros also, he has not stated anything. My lord, Mesoparagon. In fact, he has not stated how he know the petition.
That he is not stated.
Yes.
And In fact, in his cross, he stated that
Yes,
Prossy's husband
yes. Is a
used to
resident
reside at Mespara.
at Mespara.
Hmm.
Prossy's husband used to reside Mespara. Now, my lord, DW3. What DW3 has said, page 49, my lord. I am a citizen of India by birth and permanent resident of the aforesaid locality. He is of Koponi Kusi, my lord. In the above noted case, second party Lalbano is since 40 years ago. That second party is aged about 5 years now. As I know, second party's father name is that Muslimuddin and her mother name is Sukurjan Nessa. That I know the second party is somehow relative with our family. In this regard, some communication was there between us. Even I was present in the marriage ceremony of second party, which was solemnized 38 years ago. I have casting for 35 years age, by 35 years age, and I have seen second party in casting good since 1985. That all the contents made in the affidavit. So here also there is not a single statement that the father was residing in Mespara or Halangibari. No statement to that effect, madam. Even
Read
in
his cross, read his cross.
yes, madam. In cross, madam, what he has said, Prosody Lalbano মোৰ সম্পৰ্কীয় খুৰী হয় মই লালবানুক তাইৰ বিয়াৰ পিছৰ পৰা চিনি পাওঁ so Lalbano is known to her him only after marriage মই লালবানুক তাইৰ বিয়াৰ পিছৰ পৰা চিনি পাওঁ তাইৰ কেতিয়া বিয়া হয় মোৰ মনত নাই যদিও 38 বছৰমান হৈছে প্ৰসিডিৰ বিয়াৰ তাৰিখ মোৰ মনত নাই প্ৰসিডিয়ে আজি মোক সাক্ষী দিব কোৱাত মই আজি আদালতত সাক্ষী দিছো as per her Paul is giving his evidence. Prosody দেউতাকৰ নাম মুছলিমউদ্দিন তেওঁ ঢুকুৱা 12 বছৰমান হ'ল তেওঁ হলেঙিবাৰী গাঁৱত বসবাস কৰিছিল লালবানুৰ ভাইক এজন বুলি জানো তেওঁৰ নাম সকিমউদ্দিন বুলি জানো মই ভোট প্ৰদান কৰো মই 1977 চনৰ পৰা ভোট দান কৰো মই দৌলততলা গাঁৱত প্ৰথম ভোট দান কৰো বৰ্তমান খুপনিকুছি গাঁৱত ভোট দান কৰো মই প্ৰসিডিৰ পহুৰেকৰ ঘৰত বিদেশী কেছ থকাৰ কথা নাজানো So he has stated, my lord, one thing your lordship may kindly see. The proceeding, once again we may read this, my lord. Proceeding Lalbano মোৰ সম্পৰ্কীয় খুৰী হয় that means he is related to husband of the petitioner, my lord. And মই লালবানুক তাইৰ বিয়াৰ পিছৰ পৰা চিনি পাওঁ He know Lalbano only after marriage. So her marriage was taken place as per her statement itself around 1980-81, my lord. So his knowledge is only from 1980-81. Proceeding বিয়াৰ তাৰিখ মোৰ মনত নাই প্ৰসিডিয়ে মোক আজি সাক্ষী দিব কোৱাত মই আজি আদালতত সাক্ষী দিছো প্ৰসিডিৰ দেউতাকৰ নাম মুছলিমউদ্দিন স্বৰ্গীয় মুছলিমউদ্দিন তেওঁ ঢুকুৱা 12 বছৰমান হ'ল তেওঁ হালাঙিবাৰী বসবাস কৰিছিল This Muslimuddin, the father of the petitioner, he was residing at Halangibari village. Now, he has not given any evidence that this Muslimuddin, who was residing in Halangibari, was also the same person who was residing in Mesapara in 1966 and 70. That is the missing, my lord. He has not given any statement.
And now you come to page 65.
Further, my lord, his knowledge, my lord, again from his knowledge, may be tested from this another statement. Lalbanur Bhaik Ezon বুলি জানো. In fact, in other aspect, all other has said, he has two brother, my lord. So these are contradictions which cannot be accepted.
Now come to page 65.
65, my lord.
Second paragraph.
But it is not found from the evidence of DW2 and 3 that the father of the proceeding had shifted to village Halangibari and it's only plea made by DW1 in her evidence. So shifting is
Next.
Madam.
Next.
In the light of the above discussion, the proceeding MS Lalbano Begum is found to have failed to discharge her honors of proof as provided under section 9 of the Foreigners Act 1946 that she is not a foreigner as asserted under claim by her. Therefore, point for determination is affirmed. read above, his decline is affirmative. In affirmative. Decided in affirmative.
So what the tribunal found is that the claim of the petitioner
Yes.
that her parents earlier lived at Maspara, whose
Yes.
name figured in the voter list of 1966 and
66.
1970.
Yes.
And the claim of her that they have shifted to Khopunikusi and the Muslimuddin of Khopunikusi has been told by DW2 and DW3 did not mention that earlier they resided in Maspara is not there.
Yes, ma'am.
So the proceeding failed to prove that Muslimuddin, that her parents, protected presence of Maspara is the same and very person of Halongabari,
Halangbari.
who is her
Father,
parents,
parent.
right?
Yes.
So that is the finding of the
That is the finding of the tribunal, and it is on the basis of record only, my lord. Record, nowhere record says from the record, if as of now, my lord, we have not find any evidence that Muslimuddin of 1966 and 70 of Maspara has shifted to Halangibari in any point of time.
So you want to say
Only that statement is.
that the finding of the tribunal regarding the discrepancy of the age during class and manner.
That is immaterial, my lord. That will not prejudice in any manner the petitioner, because it's only the 1966 and 70. We're accepting that that person was there in 1966 and 70, Muslimuddin, in Manat Mesapara village. Only contradiction that my lord, 1997 voter list, even though it was exhibited later on, in 1997 is a big contradiction.
What is there in the Aziz Mia's case?
Yes. Aziz Mia, my lord, that is with regard to the claim of the petitioner that someone's name is there in the voter list of 1966 and 70. And if I claim that he is my father, then I have to prove it by bringing some other evidence, my lord. Aziz Mia, your lordship will find case that is WPC 2370/2023. This issue has been settled and again. This is one of the latest judgment of the Honorable Court. Para 14 of that judgment. Para 14 says, my lord, we are constrained to observe that a mere claim by a suspected person by referring to a voter list, claiming a person therein to be his father, is not a conclusive proof, and that by doing so, the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further materials or material acceptable in law. So, my lord, the claim that he is my father, that will not do. And that father is actually the father of the petitioner. That fact has to be, as your lordship has just now pointed out, a person, if the mother proceedee come to his parental house, and if I see that he is regularly coming to the house of the father, so why not it can be accepted that yes, he is the daughter of that person, she is daughter of that particular house. But that will not do, my lord. That will not prove that he is actually the daughter of that person. Actual daughter of that person, that has to be proved by bringing some other materials. Anybody can claim, my lord, but Whether she is the daughter of actually dead person or not, that has to be proved by bringing some other materials acceptable in law. For that point only, I was relying on that matter. And Gaombura certificate, with regard to Gaombura certificate matter, we have numbers of judgment. I have relied on. And also with regard to the matter, oral evidence of the DW2 entry. Oral evidence itself is not enough in foreigners' sake. In foreigners' cases, in fact, here, my lord, your lordship will find 1900-2020, 1900-2019, my lord. Noor Begum. One 2019, my lord, Noor Begum. In that case, it will be para 6, my lord. Their para 6 may be relied on, my lord, only. And just
Yes.
para 6, my lord, probably. It will be in page 4, internal page 4, second para. The statement of DW2. There it is mother, my lord. The statement of DW2, that is Zohura Begum, who claimed to be mother of the petitioner, cannot be relied upon in absence of any documents showing her relationship, either to the projected grandfather, father, or to the proceeding herself. Which is the same case in this case, my lord. Oral testimony of DW2 alone, since any documentary support cannot be treated as sufficient to prove linkage to her, to have or have the cause of the petitioner. This is the portion, my lord, which is to be relied on. Secondly, my lord, on the same line, there it was further evidence, my lord, 4020-2017.
Yes.
4020-2017, Asia Khatun. There also, my lord, para 6, internal page 3, my lord, para 2. There the father was there, my lord, father's evidence. On the same line, DW2, Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in absence of any documents showing his relationship with the petitioner. In this, we would observe that the proceeding of under Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship. So this is proof, Malad. Same aspect was dealt in Malad Bijoy Das case also, that is reported. Bijoy Das was reported, Malad, 2018, 3 GLT 118.
Just a minute. This is in which para?
Malad, earlier one.
It starts with
The statement of DW2.
Amiruddin.
Yes. Amiruddin.
Then reported judgment, you say?
2018, 3 GLT 118, my lord. They are decided as para 17, my lord. It is tried that. Yes. It is tried that mere filing of written statement and oral testimony in a proceeding under Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceeding by adducing documentary evidence which are admissible and relevant. The two documents filed with the petitioner were not proved in any manner whatsoever, and therefore the assertion of the petitioner that being the son of Bipul Das, who was a citizen of India, was therefore a citizen of India is not proved. So this is settled position. Because
This is with regard to oral evidence.
oral evidence, my lord. Now, my lord. Gambura certificate, my lord. The document has to be proved on the basis of contemporaneous record, my lord. The Gambura, I'll furnish all this judgment of my lord Gambura certificate. Only one more aspect. One more aspect, my lord. My learned senior friend was arguing that the state has not rebutted any evidence. To that effect, my lord, I always rely on the para 26 of the Sobananda Sunwal. It is said, my lord, that if necessary, the state will rebut. Now it is not mandatory. My lord, cross-examination or rebuttal of evidences will be given only when it is necessary. It is not mandatory, my lord.
No, what Mr. Sikdar has pointed out on the judgment, earlier judgment
Yes, sir.
of the division bench, right? 2013 1 JLT 941.
Oh.
There's the case where the coordinate bench of this court.
Yes.
Single bench আছে নাকি? Single bench আছে? Order করে রাখো। Fine. Okay. Order করে রাখো। পুরো দিলাম। এখানে order করে রাখো, order দিলাম। আপনার এরকম কোনো বিচার কথা কম। Photo time.
It is Abdul Mutlik case, my lord.
Abdul Khalik.
No, 2013 1 JLT 942 931.
What the court found, coordinate bench found, the appellant in his deposition in categorical term
Yes.
has stated that his grandfather name is Abdul Waheb, whose name appears in the voter list of year 1965 pertaining to Samoguri Legislative Assembly constituency. The witness numbers 2 and 3, namely the Gambura and the village of Dizubostu village, has proved the said voter list, which is marked as Exhibit Co. Witness number 3 has also stated that Abdul Waheb is the grandfather of the appellant. Such statements of witnesses have not been silenced by the state by way of cross-examination. Witness number 2, the Gambura of Bijuli Bosti, however, has stated that though the name of one Abdul Waheb appears in the voter list of 1965 pertaining to Samoguri Legislative Assembly constituency, he, however, doesn't know who is Abdul Waheb and whether he is the grandfather of the appellant. witness number 1 and 3, having categorically stated that Abdul Wahab is the grandfather of the appellant. Such evidence of witness number 2 would not demolish the case of the appellant, as revealed from the evidence adduced by him, more so when there is no cross-examination of any of the witnesses examined. So here, the court in advance have categorically found that state did not cross-examine the witnesses adduced on behalf of the petitioner or the proceeding. There is another judgment cited, that is 2015 2 GLT.
Please.
617. Where at paragraph 9,
What is name? Please. Abdul Matul.
it is Abdul Matalik, alias Matlib.
That is differentiated letter.
Is it?
Yes.
Can you tell us?
Basiran Bibi is there.
Is it Basiran Bibi?
Yes. There are 30 of the Basiran Bibi money. That is in
Do you have the citation?
this is Basiran Bibi's case.
Is it in the Basiran Bibi's case?
Yes, madam. WPC, my lord, 1002 of 2016.
1004
1002 of 2016, madam.
002.
Yes, madam. 16. It is reported. Oh, that is 2018 1 GLT 372, madam. Basiran Bibi. 2018 1 GLT 372.
Two 2018
1 GLT 370.
370.
372, madam.
Yes.
Para 30.
There are
30, madam. Reliance Plus in case of Abdul Motli, alias Motleb Mohammad Chopra, can be of no assistance to the petitioner it must as that he has already been clarified by this honorable court in previous decision that the said decision did not lay down any law was and was a decision confined to the facts and circumstances of that case. regarding discrepancies in the voter list with the petitioner contended were not her creating being entered into the by official in election commission and thereafter therefore should not be used adversely against the petitioner. Such contention is without any substance. The voter list were adduced as evidence by the petitioner herself to prove her case that she was not foreigner but a citizen of India. Petitioner cannot insist that only that portions of the voter list which are in her favor should be accepted and those portions going against her should be overlooked. This is not a how documents put forward as a piece of evidence should be examined. The document has to be appreciated as a whole.
That's the law laid down by the apex court.
Yes, ma'am.
When a particular document is placed,
Yes, ma'am.
it is not only that the favorable portion has to be accepted and it has to be taken as a whole. In that particular matter, in particular document, if something else is there,
Yes,
that has also to be taken into consideration.
consider.
Whichever it goes.
Yes, ma'am.
It cannot be pick and choose
Pick
that
and
this
choose.
particular portion is in favor of one person, so it will be picked up.
Yes.
That's the law already settled by him.
Yes, that is settled.
And what the, in this particular judgment court found that the proceeding have taken the voter list of a particular year as an evidence, want to show something.
Yes,
And it cannot be a ground that only that portion, the name or whatever, father, mother, that will be taken into consideration. And of the age or something.
Yes.
So it has to be taken as a.
that has to be taken as a whole.
That's a very old decision of the Honorable Apex Court.
Yes, madam.
And still been relied upon by the, still in force.
And so, madam, the my submission will be, my lord, the tribunal has committed no error by giving the opinion. And it may not be interfered by this honorable court. Because the larger point is, my lord, under certiorari, can we go into evidences? Can we examine the evidence which has been, my lord, appreciated by the tribunal?
Okay, anything else?
No, my lord, that's all. That's all.
Mr. Sigda, you want to add anything against the counter?
Yes, my lord. My lord, first point is, my lord, so far the judgment relied upon by the other side, my lord, my friend. In all the judgments, my lord, without all judgment, my lord, after 2005 judgment of Sarvananda Sunal. But the Sarvananda, the relevant portion of the Sarvananda Sunal paragraph 26 has not been discussed. And paragraph 26 of the Sarvananda Sunal judgment, my lord, there is a clear indication when you lead evidence, the other side is to verify the facts and let evidence in rebuttal. If necessary. That is the paragraph 26. That has not been discussed in those cases, my lord. That is one point, my lord. And so far the WS, etc. The lordship has already seen clause 3, it was only representation. Clause 3. So, my lord, evidence that the WS is not a, my lord, should not be mandatory as required under CPC. And that has been also discussed, my lord, in the judgment of the Hyderli case, referring the judgment of the Sarvananda Sunal 1 case has my lord, clearly discussed and observed that one may prove citizenship without referring accurately to all the factors mentioned under paragraph 26 of Sarvananda Sunal 2 supra. if the date of birth or the place of birth is not conclusively proved, but if the conclusively proved that the father of the proceeding is an Indian citizen, the claim of the proceeding cannot be rejected as a foreigner, as it would fly in the face of logic and common sense, my lord. And that is in the paragraph 42 of the Hyder Ali case. And paragraph 40, both all the paragraph, my lord, under 43 is relevant, my lord. Paragraph 43(1) has been given reference of the place of birth, date of birth, etc. But it has also been stated that, however, the Supreme Court nowhere states that aforesaid facts must be proved only by documents. The expression used is normally he may be required to give evidence. Thus, it is not mandatory to prove all these to show that he is an Indian citizen. These are, however, relevant facts if one proves can establish beyond doubt that he is a citizen of this country, yet he may be liable to prove his citizenship by other evidences as well. So, my lord, this is one part, my lord, the evidence, the WS is not required as under CPC, and the everything, my lord, all the facts is not also required to prove by conclusive, my lord, evidence. Then, my lord, paragraph 40, my lord, these are paragraph 42, my lord. And paragraph 43, my lord. Paragraph 43, quoting the Shirazul Haq case, my lord. Paragraph 2, 3, 4 has been quoted in under paragraph 43.
You are relaying the Hyder Ali.
My lord, Hyder Ali. Hyder Ali is quoting the Shirazul Haq case, my lord. Shirazul Haq judgment is also with us.
Been quoted there.
Yes, we did quoted there. Paragraph 4 is relevant to us, my lord. Under paragraph 43, Shirazul Haq case, paragraph 4, that is quoted under this paragraph.
47.
My lord. My lord, 2019 5 SCC 534 Shirazul Haq case, that is quoted under paragraph 43 of Hyder Ali case, my lord. That paragraph 4 of the Hyder Ali Shirazul Haq case, my lord, in under this paragraph. I am reading that paragraph 4. Having gone through these documents, we are of the view that it is not possible to state that Kamatullah is not the same, despite having named Kafatullah in some documents. These being so, the grandfather's identity, father's identity, etc., has been established successfully by the appellant. Further, the mere fact that the father may later have gone to another village is no reason to doubt this document. Shifted. So, shifting, appearing in other village as a voter, that should not be doubted, my lord. That has happened in the present case, my lord.
See, probably what we found, the Shirazul Haq case.
Yes, my lord.
See, you can have 2019 5 SCC 534.
My lord.
Shirazul.
Shirazul Haq.
It's a very small, it's a short judgment.
Yes, my lord.
Now, what had happened in Shirazul's case?
Shirazul Haq case, my lord.
What had happened in Shirazul's case?
My lord, this case, my lord, the judgment of the High Court and
Shirazul's case.
set aside, my lord.
True. The Shirazul's case, what the apex court found, that is very important. It is relating to a voter list. That is also correct. But what was there?
My lord, she was declared foreigner by the tribunal.
Don't go by
The
that.
judgment
Don't
of the
go by that.
tribunal also upheld.
Mr. Sikdar, as you know, facts of his case varies from time to time, right? It's case not similar in most of the cases. Now, what are the facts of the case? Do you have the judgment of Shirazul Haq before you?
Yes, my lord.
Now, Mr. Pine, do you have the Shirazul Haq judgment with you?
Yes, I have read it, my lord.
You have read it?
Yes.
Okay. This is only 2-page judgment.
Yes, my lord.
We can be there for some time. Read the judgment.
My lord.
Listen it very carefully. Mr.
My lord.
Sikdar, read it.
My lord. Leave granted, the present appeal raises an issue as to whether the appellant herein has been declared to be foreigner incorrectly by the Foreigners Tribunal judgment dated 19/1/2017 after referring to some of the documents produced by the appellant and after finding that there was a discrepancy in the name of grandfather and the fact that the grandfather and father later lived in different villages, the tribunal declared the appellant to be a foreigner. The High Court dismissed the writ petition filed against the same judgment, stating Sirazul Haq, case SCC online so-and-so, paragraph 23. Having said that we have to look into the written statement filed by the petitioner before the tribunal. In a proceeding before the foreigners tribunal where the citizenship status of the proceeding is being questioned, that too by the state, the proceeding must disclose all material facts within his special knowledge relevant for establishing his citizenship at the first instance itself, that is in the written statement. In other words, he must be able to plead about his identity as a citizen of India. This would be as per the requirement of Section 9 of the Foreigners Act 1946, which is in perimetria to the provision of Section 106 of the Evidence Act 1872. Thereafter, the material facts pleaded in the written statement are required to be proved in accordance with law by adducing cogent and reliable evidence. In the written statement, petitioner did not even mention his name, not to speak of his date of birth, year of birth. All that he stated was that he was born at village Sagolchora in the district of Dhubri and that his parents were voters in the voter list of 1997. His grandparents were voters of 1966, 1970. Only in the verification column, he described his name as Sirazul Haq. This is all that the petitioner stated in the written statement. This is not only inadequate, but does not in any manner lead to the identification of the petitioner as an individual, not to speak of identification of the petitioner as a citizen of India. It is not a case of violation of principles of national justice or procedural impropriety. Neither can it be said to be a case of perversity. This is the, my lord, High Court, I think.
Now just go through.
My lord. Then paragraph 2. We have heard the learned counsel for both the sides extensively and have gone through the documents produced by the appellant ourselves. On a perusal of the same, we find that number of documents have been relied upon by the appellant, starting with the voter list of his grandfather, Kamatullah, in village Shuto Basjani. There is no doubt that the great grandfather's name Amatullah appears as Amatullah throughout the document. Equally, there is no doubt about the father's name, which appears as Hakim Ali throughout. The only discrepancy found is that in some documents, Kafatullah later becomes Kamatullah. However, what is important to note is that his father's name Amtullah continues as Amtullah and other family members associated continued as such. Also produced are NRC registration details of the year 1971 of the grandfather who is not to be Kafatullah in this document. Other voter lists are then produced where the letter F becomes the letter M with other family members remaining the same. In fact, the appellant has himself produced a document of 1981 from the income tax document giving his permanent account number. Apart from these documents, certain other letter documents have also been produced, including photo identity cards issued by the Election Commission of India and identity cards issued to his brother, including voter list in which the appellant's name appears. Having gone through these documents, we are of the view that it is not possible to state that Kamatullah is not the same, despite being named Kafatullah in some of the documents. These being so, the grandfather's identity, father's identity, etc. has been established successfully by the appellant. Further, the mere fact that the father may later have gone to another village is no reason to doubt this document.
That's right.
Well,
What from this? No reason to doubt. But what? There has to be an evidence. The court did not say. And remember one thing, in this particular judgment, what they found, that Kamatullah, only the one particular letter has been changed in that particular voter list. But the accepting that particular letter in the name of a person of grandfather, the name of the remaining persons in the voter list remain intact. That's what is there. So they have accepted the voter list as it is. They have accepted because name of A, name of
Yes.
B, name of C, full name I'm
Well.
talking about, remain intact. Only the name of
Grandfathers.
say grandfather was somewhere, some particular mistake in the letter, but name of other persons remain intact. So that is how they have accepted the voter list as a whole. You cannot say the ages
Well.
or something will picked up.
Yes, ma'am.
Only in that particular, because they have accepted the voter list as a
Well.
whole, only because they found a discrepancies in one particular letter. Somehow it is not there, but the name of the other voters remain intact. Now here, even if you read that cannot establish successfully is not that because shifted is shifted. Shifting had to be proved. The court did not say anything. You read it again.
My
Having
court,
gone
the
through
Supreme
these
Court says
documents-
that shifted to other village, that can be a ground to doubt, my lord.
No, because there has to be, that is the reason. In that particular case, continuity of the voter list was there,
My lord.
which you are not placing. What we found, most of the councils, what they are saying while accepting this particular judgment, you see, there has to be, if this voter list, let us assume the name of Muslimuddin, had it been there in the village of Maspara in the year 1970, and in the subsequent list, had it been there in village Alongpara, whatever that
Alongpara.
village, right?
Yes.
After 1970, continuously, question of shifting would not have been doubtful. That's what the apex court has said. You read it again, para 4.
My lord.
But here is a case. After 1970, no voter list as a piece of evidence was adduced before the
Well,
tribunal.
My lord. Voter list
Right.
has been given, my lord, 97 voter list.
That 97 voter list is not a certified copy, as you know very
No, my
well.
lord, 97 is a certificate.
Where is it?
My lord, that was been exhibited at exhibit A, I think. my lord. And 85 voter list also annexed in the read petition, my lord.
That is-
But 97 voter list
Let us see if you have-
that has been put, that also discussed in the,
No, fine, let us see.
my
Is
lord.
it this certified copy or not?
My lord, that has been discussed also,
Okay, exhibit G,
my lord.
yes. it's a
Annexer
certified copy.
page 58. my lord.
That's right, because that is discrepancy 91,
Yes, my lord.
right?
Yes, my lord.
Now, just see. Here, this is a voter list of 1997,
97.
after which year?
After 1970.
After 1970.
My lord.
Who are the
So,
voter in that
That is
list?
the reason we are saying there has to be, if after 1970, had there been a voter list of that particular village to which you have shifted, it's a continuity. There is no reason to doubt. Where is the reason to doubt? You have to show the continuity.
My lord, 85 voter list they have, my lord, annexer page
After
69.
1970, you have shown the voter list of 1997.
My lord. But
That has been
voter
discussed.
list of 1985 voter list is also there,
1985 voter list of whom?
my lord. Voter list of Muslimuddin, my lord.
Now,
That was
after
not-
1970, 1985, after 15 years.
My lord. My lord, in this
That
case,
is
my
how, see, we cannot go beyond the decision of the apex court. We have to be there in this thing,
my lord,
right? That is the court
My-
definitely considered
my
all
lord,
these aspects.
in that position, my lord, I also want to, my lord, rely the paragraph 46 of the Hyder Ali case, my lord.
Hmm.
In that case, this honorable court has held that the voter list of 1997 and 89, between this period, no voter list was produced. This honorable court has held that it would have been better, but for that, the whatever voter list has been produced, that cannot be discarded. In paragraph 46, my lord.
Can we go beyond the act? Can we go beyond the act? Tell us,
My lord, the paragraph 46 of the Hyder Ali case, my lord.
forget that. Can we go beyond the act? Citizenship Act, section 6A,
My lord.
subsection 2
My
and
lord,
3.
requirement is that whether my parents were citizen or not. I have
think,
claimed,
Probably.
I have
I-
claimed, I have adduced evidence,
Further in
that evidence has not been reported by them, my lord.
Listen, question of rebuttal will come later. Why are you boring on that? Do you have Citizenship Act with you? Read the Citizenship Act. 6A. Do you have 6A?
Yes, my lord, we
Then
have
come
this
to
evidence.
2. 6A 2.
Two, my lord. Subject to the provisions of the section 6 and 7, all persons of Indian origin who came before the first day of January 1963 to Assam from the specified territory, including such of those whose names are included in the electoral rolls used for the purposes of the general election to the House of People held in 1967, and who have ordinarily resided in Assam since the dates of their entry into Assam, shall be deemed to be citizens of India as from the first day of January 1966.
Then read 3.
My lord, subject to the provisions of subsection 6 and 7, every person of Indian origin who came to Assam on or after the first day of January 1966, but before the 25th March of 1971, from the specified territory, and has since the date of his entry into Assam been ordinary resident in Assam and has been detected to be foreigner, shall register themselves.
So what do you mean by ordinary resident? How do you prove? From
My lord.
1970, there is nothing. You have
My-
come in 85 or
my lord.
1997.
My lord, even if, my lord, for any reason, if I fail to produce some documents, so thereby I will be foreigner.
That is the
My
reason.
lord, my parents are voter in 1966, 70. I have produced the voter list of 1997 before this honorable court, my lord. What for this, my lord? Why, well, before this? Some injustice is to the petitioner, my lord. In the writ petition, we
In
have,
that case, all who are claiming,
my lord.
all those who are claiming to be against whom there are FT cases are pending.
My lord.
By mayor making oral submission would have been enough. Why do you need voter list? You produce Gaumbura, you
My lord.
bring some ABCD,
My lord,
place the judgments,
my lord,
place the oral evidence and finish it off.
yes,
To make otherwise Sarvananda Sonal 1, the judgment you have read, in one if you have read properly, then what's the requirement of FTs? Make the oral evidence before the FTs. Why should you sit here? A division bench, 2 judges, wherever it is wasting time for no reason. If that is a case, produce the oral evidence. Make it correct. How do you prove your established
No, my lord.
citizenship?
my
You
lord,
bring somebody,
my lord,
you bring a village headman, giving a certificate without any record. And village headman is insisting, I know him, I know her parents, I know his parents. And that's it. Another Mr. C will come, he will say, yes, I know her, I know him since my childhood. They're living in this area. I know his father's name. Without saying since when they are residing in this village. Without saying that before this village, they were residing in that village. No evidence. Make them citizen of India.
no, my lord.
Why not?
Yes,
This is
my-
the case here
My
similarly.
lord, I am not on that, my lord.
Oral evidence is
we have-
sufficient. If we see basically why the tribunal is required to find out the evidence on the basis of the evidence. And we are here to find out whether the tribunal have, because as we have to exercise this certiorari, we have to find out whether the tribunal rightly or wrongly gave his finding. That's all. Right? Anyway, make your written argument if you want by Friday. You have a holiday tomorrow. And Mr. Fine,
Huh?
you are
My
leaving
lord,
at
I may
Hyderabad
be-
Leon. Any
I
other
may-
judgment?
Might be
You
given
have
on
already
Monday, my
decided.
lord. Monday next month.
Monday, these bands may not be available, then you have to give it to our bank assistant. Monday,
Friday,
tomorrow is a
okay,
holiday.
okay.
Give him Friday.
We'll try to give it by tomorrow itself.
Tomorrow is a holiday.
My lord, on
That is
Thursday,
why
my
we are
lord.
telling you Friday. Tomorrow you are getting a holiday.
My lord,
Otherwise, we would have asked you to give it on Monday.
my lord, I may not be available on Friday. My friend will give it, my lord.
Yes, give it.
Yes, my lord.
Heard Mr. Ayer Sigda, counsel appearing for the petition. But Mr. Sigda.
My lord,
don't
there
get
are judgment of the Supreme Court, my lord. Oral evidence is enough, my lord. That Anil Sharma case, my lord. I'll produce in the written argument, my lord.
Sure, sure. You are free to do that. But don't give a long.
No, my lord.
And Mr. Z. Payne, Studying Council, Home Department, Assam. For the response number 2 and 3. As well as Mr. C.S. Hazarika, right? HK Hazarika. Learning Government Advocate, Assam, for the response number. Where is the records? Order is. I'm good at it. The
Paragraph.
Mr. Sigda,
46.
as well as Mr. Pine. That council representing the petitioner and the Home Department as well,
Paragraph 90.
shall file their written arguments
120.
on 2nd of February. List according.
Misinterpretations.
Yes, Mr. Hazarika, we wanted to know the status of that case. Do you have it?
By the IGP Lordship.
What is the status now?
Also, in this letter, Lordship, one national inquiry report which earlier provided, today also provided, Lordship.
Same report.
Same report, Lordship. Lordship, have a look, last line of last page in para number 7. Boda IOS has stated that the cases are still under investigation. Lordship, today I make a communication with the concerned officer that whether the investigation is completed or not. He informed me that already FIR has submitted in both the cases, Lordship. So I may be allowed to produce the FIR from the concerned police station, Lordship.
By our order earlier. Directed. The Director General Police Assam. Order dated 04/01/2020. Directed the Director General Police Assam to apprise the court about the status of Amaguri Police Station, Amguri Police Station case number 66/2013 and police station case numbers 66 of 2013 and 67 of 2013. That were referred at paragraph 7 in the magistrated inquiry report submitted on 24/02/2014 pertaining to Amguri PS case number 66 of 2013. Mr. H.K. Hazarika, learned government advocate Assam, on telephonic instructions, the respondents in the Assam Police Headquarters apprised the court that in both the Amguri police cases, after investigation of the matter, final reports were submitted. After such submission, next paragraph, of the respondent in the Home Department, the state, the Director General of Police Assam, response number 5, on the next date fixed, shall apprise the court about the number and date on which such FR were submitted in Amguri PS case number 63 and 66, 2013, 67. And the status of those submitted and before which authority, and the authority before whom those were submitted is equal. The Director General of Police Assam shall also apprise the status of those efforts filed in said previous case number 66 of 2013 and 67. List on two 2024. So you'll be telling us the numbers of the effort, the date before whom we have filed, and also the status of those efforts before whom we have filed, whether it has been accepted after issuing notice to the petitioner.
Lordship, as per the information in 2015, one FIR is submitted. In the year of 2015, one FIR has submitted by the police in connection with Amguri PS case number 67, 2013.
Another affair.
Another FIR is submitted on 7/5/2017. I will put this all record on the next step.
লগতে এইটো লিখো। In its report, the DGP Assam shall also apprise the court as to whether the informant of those Amguri case number 66, 2013, 67, were communicated regarding such affairs in those cases as required under section 173 within bracket 2 of the CRPC or not. Read back your copy of this order to Mr. K.S. Hazarika,
HK Hazarika.
H.K. Hazarika, Government Advocate Assam. For his necessary communication in necessary use and further communication.
Your Lordship, I was ready, but Your Lordship, one matter, Your Lordship, in item number 26 going on, Your Lordship. On 8, Your Lordship.
Just let us see. 8 we have to you now. Right. 13th or 15th, because that week we'll be having interviews.
Lordship.
That's the reason we have to rise early in
Yes,
that
yes.
case, and then it will
On
be
13th, then Your Lordship,
on 13th.
13th.
Mr. Das, we have it on 13th.
Since it's the UAPA matter, Your Lordship, I will.
Okay, you have to go actually. Mr. S. Botakul and counsel appearing for the petitioner. Prayed for a short accommodation as he is in the midst of another ongoing matter. In another court. To which Mr. D. Das, learned additional public prosecutor Assam has no prayer allowed. As agreed by the council for the purchase placed on 13th of.